Hey guys, we have a bunch of docket updates in the Fat Joe, Terrence Dixon, the two cases that relate to both parties. Namely, and you may have seen a recent update I did saying that Tyrone Blackburn apparently planned to withdraw as counsel in this matter, in these matters, the related matters. And we have that information from what I had highlighted here, a July 1st letter to the court from Fat Joe's team. And more specifically, this little paragraph is part of this letter here, that on Monday, June 29th, Tyrone Blackburn represented to Fat Joe's counsel that he will be filing a letter with the court on the morning of Tuesday, June 30th, advising of my withdrawal as counsel for Mr. Dixon in both matters. And then since they filed this letter on July 1st, they're like, well, he never filed that notice to the court, so we're going to let the court know. So back over to the docket. We're going to do a lot of docket jumping today. On July 1st, Tyrone Blackburn did file something with the court, but it wasn't a letter saying he planned to withdraw. It was an opposition to Rock Nation's motion for sanctions in Dixon v. everybody. So he got some filing done, but he didn't notify the court that he planned to withdraw, but he made sure he got in his opposition to any further sanctions filed in that matter. Jumping to July 6th, you'll see that we have an update here, a letter from Tyrone Blackburn, and he's confirming that he's paid invoices that, remember, Judge Rochon ordered, look, at first I'm not going to sanction you. The sanctions orders that we have more recently came from Judge Willis. Judge Rochon earlier this year was like, I'm going to forgo like punitive sanctions, but I'm going to make sure you pay the costs associated with scheduling and then not appearing for the February 6th and 9th depositions. So Blackburn files this letter just showing that he paid the Veritext, the court reporter, bills for those missed depositions. Then on the 7th, yesterday, we have these two filings. We get these two filings come in. So we have a letter addressed to Judge Jennifer Willis from Fat Joe's team, and it's an Excel sheet containing a bunch of fees and a bit important. So this one we're going to read in full. So we got the big header here, big green header, slime green, if you will. There we go. The amount of money on those court reporter bills was like a few $100s. It wasn't anything like, I don't know if it reached four figures for either deposition. All right, so here we have this July 7th letter filed by Fat Joe's team. Dear Judge Willis, we write pursuant to sections 1A and 2G of your Honor's individual rules of practice in civil cases and in accordance with your Honor's order dated June 23rd, 2026. The order directed plaintiff to 1. Email the court an Excel sheet detailing the attorney's costs and fees with opposing counsel copied, and file a letter on the docket providing the date and time the Excel sheet was emailed by July 7th, 2026. And 2, to meet and confer with defendant and file a joint letter with the court confirming the date of Mr. Dixon's follow-up deposition by July 7th, 2026. So, hey, this is nothing new in this case. We are following your orders. Judge, you have your own rules. A lot of judges do. You told us what they were. We did what you asked us to, but we have a problem. Why do we have a problem? With respect to your Honor's first directive, plaintiff's counsel emailed the court an Excel sheet detailing the attorney's costs and fees, with opposing counsel copied on the email at 4:30 p.m. on July 7th. As to the second directive, plaintiff's counsel has diligently attempted to meet and confer with Mr. Blackburn regarding the scheduling of Mr. Dixon's follow-up deposition, to no avail. Specifically, and there's a footnote coming up, plaintiff's counsel emailed Mr. Blackburn on 3 separate occasions. So they attached the email chain, we can look at that, seeking confirmation of Mr. Dixon's availability for the July 28th, 2026 at 10 a.m., first on June 25th, again on July 2nd, and a third time on July 6th. And to date, Mr. Blackburn has not responded. And remember, he's still counsel of record. He's still counsel of record. So it's still on him to reply. And he's been told, not just by this court, but other courts, but especially this court, one of our rules, just try to meet and confer. Try not to get the court involved for these simple communications back and forth. Like, do that. That's the bare minimum. But here he's apparently not responding. So they say here, Fat Joe's team's letter goes on to say that while Mr. Blackburn has failed to respond to plaintiff's efforts to schedule Mr. Dixon's follow-up deposition on June 29th at 7:26 p.m., he sent plaintiff's counsel an email stating that he'd be filing a letter with the court the following morning, June 30th, advising of his withdrawal as counsel for Mr. Dixon in both matters. Mr. Blackburn has not been granted leave to withdraw as counsel in the current case, nor has he responded to plaintiff's request regarding Mr. Dixon's availability. So now on July 7th, they're like, look, he still hasn't told you, even though he told us on the 29th that he would tell you on the 30th, and now it's July 7th, and we're not getting him responding to these other matters that he's still counsel of record for. He still hasn't told you that he has these supposed plans to withdraw. They point out that Mr. Blackburn has not been granted leave to withdraw as counsel in the current case, nor has he responded to plaintiff's requests regarding Mr. Dixon's availability. Your Honor's order expressly found that Mr. Blackburn impeded and frustrated Dixon's deposition, and that consequently a second deposition is warranted, and they cite the order. In addition to ordering a follow-up deposition, the court sanctioned Mr. Blackburn by directing him to pay attorney's fees and referring him to the grievance committee based on his conduct during the pendency of this case. So this is not Judge Rochon's cost of the court reporters for the 6th and 9th. This was Judge Willis's sanction order. Despite that recent sanction, Mr. Blackburn has failed to comply with the court's order by ignoring plaintiff's repeated requests to meet and confer regarding Mr. Dixon's availability, thereby risking further unnecessary delay and additional attorney's fees in this litigation. Accordingly, plaintiff respectfully submits that Mr. Blackburn's failure to respond to plaintiff's repeated requests should preclude any later objection to plaintiff's proposed deposition date of July 28th at 10 a.m., and plaintiff therefore respectfully requests that the court deem Mr. Dixon's follow-up deposition scheduled for July 28th at 10 a.m. or grant such further relief as the court deems appropriate. And then signed by Tacopina there. And they did attach the email chain just to show, like, look, we did reach out on these dates, following up again, following up on the below, please confirm. And there you go. So the 2 follow-up emails that purportedly got no response. And then after this letter came in, then we have this. And this is short. So when there's a motion filed for something like, in this case, a motion that we have a counsel that wants to withdraw, we'll typically see a memorandum of law in support of that motion. So this was real quick filed later on in the day on the 7th, after that letter was filed with the court that we just read. And it quickly notes it's from Blackburn to the Honorable Court and to all parties and their counsel of record. Please take notice that pursuant to Local Civil Rule 1.4 of the U.S. District Court for the Southern District of New York, and consistent with Rules 1.7 and 116 of the New York Rules of Professional Conduct, undersigned counsel Tyrone Blackburn of T.A. Blackburn Law will move this court before the Honorable Judge Jennifer Rochon, on a date and time to be set by the court for an order, 1, granting undersigned counsel leave to withdraw as counsel of record for defendant Terrence Dixon, staying all proceedings, deadlines, and obligations in this action as to defendant Terrence Dixon for a period of 60 days from the date of the order, to afford Mr. Dixon a reasonable opportunity to retain substitute counsel, apply for pro bono counsel through this court's pro se office and pro bono counsel program, or C, elect to proceed pro se. 3, adjourning the proceeding presently scheduled for July 7th. Remember, this is being filed on the 7th. So we're getting a request on the 7th to adjourn the proceedings presently scheduled for July 7th, and any other pending deadlines applicable to defendant Terrence Dixon until the conclusion of the 60-day stay, and 4, granting such other and further relief as the court deems just and proper. Then we have, please take further notice that Tyrone Blackburn and T.A. Blackburn Law do not seek leave to withdraw as to themselves in their capacities as defendants in this action. Mr. Blackburn and T.A. Blackburn Law will continue to appear pro se as defendants following the requested withdrawal as to defendant Dixon. This motion is necessitated by a non-waivable conflict of interest that has arisen and crystallized through events postdating undersigned counsel's appearance in this action, and by considerations of the personal safety and well-being of undersigned counsel. The grounds for the motion are set forth in detail in the accompanying declaration of Tyrone Blackburn. This motion is based upon this notice of motion, the accompanying declaration and its exhibits, the proposed order submitted here within, and the pleadings and papers on file in this action, and such argument as the court may permit. So pursuant to Local Rule 1.4, copy of this notice and the accompanying declaration and exhibits, and the proposed order has been served upon defendant Terrence Dixon at his last known address and upon all counsel of record. So there we go. He submits this initial motion. A time to be had. And then hitting the docket today, which is why we're doing this, because I don't want to get too far behind. There's a lot of things going on at once. We still need to go over, and I talked about it a bit over on X. I had this idea that we would briefly cover Tyrone Blackburn, his arguments in response to Rock Nation, represented by Alex Spiro, his motion for sanctions against Tyrone Blackburn in the collateral, the companion case. I figured we'd go over the arguments, Tyrone Blackburn's response to that, and maybe do a hybrid stream talking about 3 new lawsuits recently filed by Tyrone Blackburn against a number of parties. Here it's shorthanded to Tyrone Blackburn versus Joe Tacopina, Tyrone Blackburn versus TMZ, and Tyrone Blackburn versus Reed Smith, but there are more parties named in each of those lawsuits. It's over like 10 parties named total. It's like 355 pages across these lawsuits. So I haven't really had the bandwidth or the time, and I want to read them kind of thoroughly. They're long. But we might end up doing, we'll get to that on a stream, and maybe I'll find the one that's like the meatiest, and we'll read through the full length of whichever one is the meatiest. Maybe the Joe Tacopina one. I don't know. And then I'll just look for any notable differences, and we'll loop in the highlights from the other two. That way we don't have to read 350 something pages. But just so you know, we are going to get to a stream on that. These lawsuits are going to be a critical piece of Tyrone Blackburn's argument to withdraw. He's going to say, look, I can't properly advocate for Terrence Dixon when I'm also a witness to underlying issues that are subject to this lawsuit that now puts me in a position where there's an unwaivable conflict. So we're not going to read these full things today, but just know that that's what's being referenced when we see mention of them. And we are going to look at some of the other exhibits. Let's see. Is this the memorandum of law? Okay, we're going to start with the memorandum of law, which that's going to be more of the legal argument. And then the affidavit. With this case, previous memorandums, filings that also had an affidavit from Tyrone Blackburn, the language was often very, very similar. Like 90% of the affidavit was exactly the legal argument in the motion. Here we actually have a difference. Here we have legal arguments, and then the affidavit is more of, I'm signing off that I have personal knowledge of this deposition, of this incident, of whatever. So they are actually different for once. So we're going to read both. We haven't had to do that previously. But first, let's get the legal argument, and then we'll get to the affidavit, which will talk about some of these exhibits. Yeah. Hybrid, you say? Hybrid, you say? And hey, everybody, by the way. Hey, everybody. Brooklyn says nobody messes with Tacopina. I mean, he's got to deal with Relly still in the suit where he's a co-defendant with ASAP Rocky. And now he's got to deal with Tyrone Blackburn, defend himself against Tyrone Blackburn in the civil suit that he just filed. So people trying to mess with him. We'll see how it goes. People trying to mess with him. And Brooklyn, he's in the process. He's in the process of seeking to withdraw. And I have questions about the arguments, but we'll get to that. I'll let you know my thoughts after we read it. So we've got, let's see. I'm just going to say the Blackburn parties. It's him and his law firm, but he's a solo practitioner. So we're just going to say Blackburn parties. Or he's calling himself withdrawing counsel. That's the phrase he's using. We'll go with that. So they're seeking leave to withdraw as counsel for Terrence Dixon and for a 60-day stay of proceedings as to Mr. Dixon. 3 independent grounds each compel withdrawal. So he's going to make 3 different arguments here. First, he's going to summarize them. Withdrawing counsel is an adverse plaintiff litigant in 3 pending state court actions. So these are the cases where he's suing Tacopina, TMZ, and Reed Smith, and more. All naming plaintiff's own counsel of record. So when they say plaintiff here, they mean Fat Joe, When they say plaintiff litigant here, he's referring to himself. So he's the plaintiff in those suits, those 3 lawsuits. And in this matter, this plaintiff refers to Fat Joe's own counsel and their retained agents as defendants. And one of those retained agents is going to be the process server. The process server from the now dismissed criminal case against Tyrone Blackburn from last year. This created a non-waivable conflict under Rule 1.7. Second, withdrawing counsel is a material witness on contested facts at the core of this litigation, borrowing continued advocacy under Rule 3.7a. And the third argument, that the circumstances giving rise to that conflict have produced genuine and irreconcilable hostility, constituting independent good cause under Rule 1.16c7. And I wonder if he's going to lean on this as being like, look, Your Honor, the reason I'm not following your rules and trying to meet and confer and handle these quick communications with opposing counsel without having to get you involved or without them having to write to the court, because it's never me writing to the court, it's always them. There's just this irreconcilable hostility, and it's their fault. It's not mine. They say the full factual record is set forth in the accompanying declaration of Tyrone Blackburn, and we're going to read that in full. But let's look at the legal arguments. They're going to argue here that no party will be prejudiced by the requested relief. It's not a big deal to issue a 60-day continuance, and it shouldn't matter to them withdrawing. They say no trial date has been set, no dispositive deadlines are pending, and discovery has not closed. Now remember, at least as far as the Fat Joe case, the initial lawsuit, the initial case against Terrence Dixon, Tyrone Blackburn, and the law firm, discovery has been closed since earlier this year, and it only remains open for the limited purpose of getting those depositions with Dixon and Blackburn completed without issue, because they had to be rescheduled, and then we need a do-over because of the conduct at the deposition, right? That's part of Judge Willis's recent sanctions order. And each of those times, throughout each of those arguments, Tyrone Blackburn's like, well, you should deny this relief that they're requesting, but if you do give relief, you should reopen all of the discovery. And both Judge Rochon and Judge Willis were like, no. The discovery is only going to be extended only as it relates to these depositions that there continues to be issues with. It's not a free-for-all for you to reopen things. It's not a free-for-all for Terrence Dixon to get his depositions done. He never, and to me this is on Tyrone Blackburn's shoulders, they never deposed Fat Joe. I don't know. You have a countersuit against him. Like, maybe you're just waiting to do discovery in that case, even though you're asking for stays as the collateral matters proceed. But in this instant case, you would think that you would ask to depose Fat Joe, who's claiming you defamed them, because some of that information, the questions you could ask him during a deposition, in theory, could go to your defense as Tyrone Blackburn, a named defendant, could go to the defense of your law firm, and could go for you setting up a defense for your client. And none of those things happened. But he's insisting here that discovery is not closed, and he's not specifying that it's only open for the limited purpose of this deposition. So my eyebrows are raised. They say a 60-day stay is the minimum time Mr. Dixon needs to retain qualified substitute counsel. And I don't think that this is going to be an issue. I mean, maybe it's also something that will benefit Tyrone Blackburn, because it would be a delay for his matters as well. He's still part of this case as a defendant. But I don't imagine this being a problem for Terrence Dixon to obtain from the court. And they cite some cases. And then these 3 separate arguments. So they go for the issue of Rule 1.4. An attorney may be relieved only by order of the court upon a showing of satisfactory reasons and consideration of the posture of the case. So where are we? According to 1.4b, courts balance the client's right to chosen counsel against the need to preserve professional integrity, resolving doubts in favor of withdrawal. Once a genuine conflict has arisen, compelling counsel to continue when withdrawal is warranted would risk ethical violations, and the attorney's duty to the profession overrides the court's calendar interest. So basically, just because you want to speed your calendar along, court, you can't let that like speed demoning stamp over someone's due process. Rule 1.16b1 mandates withdrawal when representation would violate the rules of professional conduct. Rule 1.16c7 permits it for other good cause. And so we're going to get an argument on both grounds. Next, we have the advocate witness rule, Rule 3.7. Now, this would relate to if Tyrone Blackburn needs to testify about underlying matters at the heart of any of this litigation. Now you're in a position where you're a witness, but you're also representing another party in the case. So that becomes a conflict. So going into the specifics, they say Rule 3.7a of the New York Rules of Professional Conduct provides that, absent narrow exceptions, a lawyer shall not act as advocate before a tribunal in a matter in which the lawyer is likely to be a witness on a significant issue of fact. The rule exists to prevent taint. A fact finder cannot reliably assess the credibility of an attorney who appears both as an advocate and as a potential witness on contested facts. And they cite here a Second Circuit case, Murray v. Metro Life Insurance. A law firm may be disqualified by imputation under Rule 3.7b only if the moving party proves by clear and convincing evidence that the witness attorney will provide testimony prejudicial to the client, and the integrity of the judicial system will suffer as a result. Now, what's interesting about this is when we read through the deposition of Tyrone Blackburn, I believe it was the first one that remember when they called the judge and they had to reschedule Tyrone Blackburn's deposition? I think it was the first one. But they did try to ask Blackburn some questions about, and you don't think it's an issue for you to be representing Terrence Dixon, to continue to represent him in this matter when you could be a witness to some of the issues here? And it was basically a no. There were some objections like, oh, an answer would be attorney-client privilege. I don't know. So it's just been something in the back of my mind where it didn't seem like it was many, many months before Tyrone Blackburn ever filed these lawsuits against Joe Tacopina. It just never seemed like a good idea to have him be counsel of record for Dixon, when it seems like even though they're co-defendants, the potential defenses that Dixon could raise, oh, I was only doing this at the advice of my attorney, Tyrone Blackburn. It seemed like an issue that he's also your attorney. So we'll see how this goes. We'll see how this goes. But it's just been something that's been very interesting watching this case proceed this way, and the timing of this. I really think this argument and maybe even the filing of those 3 lawsuits might be a cover your ass. A very big, elaborate way to cover your ass, potentially. So anyway, back to the argument here. They say that here the standard is easily met. Withdrawing counsel has already testified before a Kings County grand jury about the core operative facts at issue in this case, has commenced 3 civil actions arising from the same events, and is the named adverse party to plaintiff's counsel in all 3 suits. So these are suits that he filed himself. These civil actions are suits that he filed himself, and he's now relying on to withdraw in this matter. This Kings County is the criminal grand jury related to the issues with the process server. That case is now, they returned a no true bill. So when they represented the case to a grand jury, the grand jury did not indict. And then they say his withdrawal under Rule 3.7 is not a closed question. And if this is like a lot to follow, because there's like really so many layers on this case, like that clip with Tyrone Blackburn saying so many cases, to me, it applies to like how much is going on just in relation to Fat Joe and Terrence Dixon, let alone any other cases that don't involve either of those parties whatsoever. There's so much just within the umbrella of the Fat Joe cases. So if it's hard to follow, I feel you. I feel you. And if you feel like you already know, and I'm repeating some of this context just to help anyone along who may be forgetting. What do you mean Kings County? What do you mean these civil lawsuits? So sorry if it's repetitive, but there's a reason I'm doing it. All right, then they've got the application. Withdrawal is mandatory and the record compels it. So first argument, first basis here, a non-waivable personal interest conflict exists under Rule 1.7. They say withdrawal counsel is currently an adverse plaintiff litigant in 3 pending state court actions. Again, all filed by himself. He's the plaintiff in all of them. So Blackburn v. Joe Tacopina et al., which is defamation and tortious interference against plaintiff's lead trial counsel and his firm. Next is Tyrone Blackburn v. EHM Productions and doing business as TMZ, and I think Fox is named in this, and a few other media outlets. And that's arising from defamatory statements broadcast at plaintiff's counsel direction. So the underlying claim in this case against the media outlets is you guys were acting as a mouthpiece, basically almost like an agent, on behalf of whatever Joe Tacopina and Fat Joe's other attorneys from Reed Smith fed to you and told you to go out and report. And we're going to read those. And then specifically in relation to the process server matter. And then 3, Tyrone Blackburn v. Reed Smith, the law firm, and some of the, I believe this is the one where the process server is named as a party as well, but I could be wrong. But we'll get that straight when we do the full stream, the full deep dive on those. So here he says we are asserting claims against Reed Smith, Ian Turetsky, the Hunt Group, James Hunt. James Hunt is the process server, and this is his PI firm, and Nicholas Palmieri, rising from the May 12th, 2025 incident and an October 14th, 2025 ex parte transmission to the Kings County District Attorney's Office. So this is an email that I believe it was Turetsky sent over to the Kings County DA's office. So when we get to that part of the affidavit, we'll look at that. Rule 1.7A2 bars representation where there's a significant risk that the lawyer's personal interests will adversely affect professional judgment. That risk is not theoretical here. Every adverse party in those 3 actions is plaintiff's own counsel of record or their retained agents in this case. And I think this is going to be somewhat of a problem. I'm not saying that they won't let him withdraw. I think I would. Oh, I feel like the right thing for any defendant would be to allow Tyrone Blackburn with this posture to withdraw and allow them the opportunity to find other counsel. But I can also picture some type of acknowledgement in the order granting such withdrawal that would point out, like, look, this issue with the process server and Kings County, your deposition, if you're going to say that you've become a witness in that case, and because you're a witness in that matter, which is now over, it's dismissed, which I don't see how that wouldn't help your client. If you're relying that on the purpose to say why you're withdrawing right now, you should have brought this to the court's attention when you gave testimony, when you became a witness back then. Why are you raising this as a basis for withdrawal presently? Is it only because you went and filed these lawsuits? Right? And it's a little bit, it seems to me like if you're going back in time to cite to some of these issues, you had some awareness that maybe you weren't in the best posture to represent your client in this matter previously, but you chose not to say so. So while I think I don't think he'll continue as counsel for Dixon, I'm curious if in the order allowing that withdrawal, we'll see some type of like, but just gonna say, maybe you should have thought about this sooner, but okay, you can withdraw. So Rule 1.7b permits waiver only upon a credible certification under Rule 1.7b1 that competent and diligent representation will be provided notwithstanding the adversity. No such certification is tenable, and then withdrawal is mandatory under Rule 1.16b1. Then the material witness issue. So Rule 3.7 independently compels withdrawal. The May 12th, 2025 incident, the service attempt at withdrawing counsel's home, and the ensuing vehicular assault narrative is a central factual dispute in this litigation. Plaintiff's amended complaint devotes significant allegations to accusing withdrawing counsel of assaulting the process server. Withdrawing counsel has already given sworn testimony before a Kings County grand jury on those same facts. That grand jury proceeding and the ex parte transmission that preceded it are detailed in the Blackburn Declaration. So cool, we'll get to see a little bit about that. Counsel cannot simultaneously serve as Mr. Dixon's advocate and as a material fact witness on the same contested events. And again, the reason I think this is so interesting is because he's relying on this process server incident and not on the underlying communications, pre-litigation communications that are the basis for Fat Joe's initial complaint against Dixon, Blackburn's client, and Blackburn and his law firm themselves. We're not even going to acknowledge that being a conflict of interest or an issue. We're solely relying on this process server issue. I just think it's so interesting. I just think it's so interesting. Like, it's just so, it just to me reads like, still, even in the motion to withdraw, which is, in my opinion, the best thing for Dixon, and it should have been done way earlier. Because I think Dixon can point the finger at Blackburn and say, "You are my attorney. You're the one who said, all right, let's send these communications to Fat Joe's team." I think the appropriate defense for Dixon's probably going to cross into that territory. And all of this time, it's something that it seems like, don't say that, don't say that, don't get into that. All the issues with these depositions. And now to have this other reason to withdraw, it's almost like it's keeping Dixon in good graces and trying to perhaps not have Dixon want to throw you under the bus in his own defense. I don't know. That's just the vibe I get from it. That's all my own speculation. But just something, it just seems so interesting about the timing of this. Anyway, let me read. They say that Rule 37A does not permit this. You can't be the counsel of record and be a material fact witness on the same contested events. And because Joe Tacopina referenced this process server incident in the amended complaint, we're treating this now as being the same contested events. The narrow exceptions do not apply, and those are that the facts are fiercely contested, the anticipated testimony is unrelated to the nature or value of legal services, and any hardship to Mr. Dixon is addressed by the stay. So this is why we're asking you to grant a 60-day continuance. Next, they argue that we've got irretrievable hostility constitutes independent good cause under Rule 1.16c7. Independent of the foregoing, the circumstances described in the Blackburn Declaration have produced genuine and reconcilable personal animosity. I think the personal animosity may have preceded this recent Kings County and lawsuit thing. Withdrawing counsel was arrested at 5 a.m. on a felony charge predicated on a narrative that plaintiff counsel broadcast nationally, a narrative plaintiff's own process server contradicted in his sworn, and they cite where they filed this, ECF number 20 affidavit. The resulting indictment was dismissed by Justice Fong Frederick under New York Criminal Procedural Law 210.35. A second grand jury returned a no true bill. That proceeding is closed. The animosity it produced is not, and requiring withdrawal counsel to continue litigating against the same parties responsible for those events would guarantee a degraded representation for Mr. Dixon. That constitutes good cause under Rule 1.16c7. And finally, the posture of the case supports granting the requested stay. So this action's in its early stages. No trial date's been set. The Rule 11 motion has been resolved. Dispositive motions have not been filed, and discovery has not closed. There are no imminent deadlines that a 60-day stay would disrupt, other than the conference presently scheduled, which withdrawing counsel respectfully requests be adjourned to permit an orderly transition. New York Criminal Procedural Laws 321, Section 321, contemplates a stay upon substitution of counsel. 60 days is the minimum Mr. Dixon needs to retain substitute counsel, review the record with new counsel, and file a notice of appearance. Imagine having to take over this case. Oh my goodness. My goodness. And it's interesting because a lot of the other cases that Blackburn's the counsel of record in whatever way, plaintiff, defendant, whatever. There are several cases where Heather Palmore and her law firm have stepped in and filed a notice of appearance in other cases, and Blackburn's staying on as counsel of record, but they're just jumping in. And Heather Palmore represented him in the Kings County matter. So I have not yet seen a motion that Heather Palmer is going to file a notice of appearance here, or perhaps represent Dixon. But it's kind of interesting that her name's popping up in all these other cases. It'd be interesting if she doesn't step on board for this mess. Maybe this mess is too much. Maybe she will. Maybe she will. But what would be different here is that Blackburn seems to want to continue pro se, at least currently, as represented in today's filings. And no, in the other cases, it was like instantaneous, like notice of appearance by Heather Palmer was filed, and there'd be another filing. The filing would say Blackburn planned to stay on as well. So it's just a lot. It's just a lot. We'll see. Plaintiff suffers no prejudice. Let's see. No dispositive briefings pending. No trial date will be displaced. Plaintiff's own counsel has an interest in this motion being granted because continued representation by an ethically compromised attorney would expose every order and judgment in this action to challenge on conflict grounds. So they're... Oh, I love this. It's a good argument. It's a great argument. But it's just funny when an attorney makes an argument like this. It's like a self-slap. You got to be like, well, they wouldn't want an ethically compromised attorney like myself to stay on this case. It's just funny the way these arguments are worded. Withdrawing counsel is not asserting or retaining a retaining or charging lien. Mr. Dixon's complete file will be delivered promptly. So I wonder if this goes back, if it was all just like contingency or what. Because, I mean, there could still be payment due, some agreement of payment, and withdrawing counsel could be like, look, I'm not going to prevent the release of your case information just because you haven't paid me up. But maybe there is nothing to square away. We never got information on that. Mr. Dixon's complete file will be delivered promptly, and withdrawing counsel will cooperate with successor counsel. Withdrawing counsel will continue to litigate as a pro se defendant throughout the stay period and will file a motion for summary judgment on behalf of himself and TA Blackburn Law in the coming weeks. Oh, man. And then the conclusion. For the foregoing reasons, withdrawing counsel respectfully requests that the court 1. Grant leave to withdraw as counsel for defendant Terrence Dixon. 2. Stay all proceedings, deadlines, and obligations as to Mr. Dixon for 60 days so he can retain substitute counsel, apply for pro bono appointment, or elect to proceed pro se. And 3. Adjourn for all future scheduled appearances and grant such other and further relief as the court deems just and proper. Respectfully submitted, Tyrone Blackburn, TA Blackburn Law. All right, let's get to the affidavit. Open the affidavit. And again, if you're tuning in late, when the exhibit mentions like the Kings County, the criminal case, and the lawsuits that revolve around the Kings County now dismissed, closed criminal case that was brought against Tyrone Blackburn, and the 3 resulting lawsuits that Blackburn has now filed against the attorneys and the media outlets, if it seems like we're glossing over that, it's because it's like 300 and something pages. So we're going to do a separate stream on those lawsuits. But when you see them referenced here, that's what's being referred to. So, and again, I'm very glad that for what seems like the first time in this case, this affidavit isn't just a regurgitation of the legal arguments that we just read, right? We have a distinct memorandum of law with the legal arguments, and now it seems like we're going to get different stuff in the affidavit, which is what I'm used to seeing in every other case when someone files a supporting affidavit. So here we go. Affidavit here of Tyrone Blackburn. He says he declares under penalty of perjury under the laws of the United States of America as follows. He's an attorney duly admitted to practice before this court and the principal of TA Blackburn Law. I appear in this action in 3 capacities. 1 is counsel of record for defendant Terrence Dixon, 2 pro se for defendant Terrence Blackburn, and 3 on behalf of defendant TA Blackburn Law. I submit this declaration in support of my motion, pursuant to Local Civil Rule 1.4 and consistent with Rules 1.7 and 1.16 of the New York Rules of Professional Conduct, for leave to withdraw as counsel for Dixon only, and for a 60-day continuance for Mr. Dixon. I have personal knowledge of the matters set forth herein, except where stated on information and belief, and to those matters I believe them to be true. If called as a witness, I could and would competently testify to the matters set forth herein. This action was commenced by Plaintiff Joseph Cartagena on or about April 29th of 2025. Plaintiff is represented by Joseph Tacopina and Chad Siegel of Tacopina Siegel Trial Lawyers, doing business as Siegel and Diorio, together with Jordan Sieve and Ian Turetsky of Reed Smith. So he's just going to call all of them plaintiff's counsel. Defendants previously moved for sanctions pursuant to Federal Rule of Civil Procedure 11. That motion has been decided by the court. Why don't we say what the decision was? Events giving rise to the disqualifying conflict. The circumstances giving rise to this motion did not exist at the time I undertook the representation of Mr. Dixon. They have crystallized over the past several weeks and taken together, they just crystallized themselves on their own. Taken together, now make continued representation of Mr. Dixon in this action ethically impermissible and, as a practical matter, incompatible with the effective and safe conduct of Mr. Dixon's defense and prosecution of his civil action against Mr. Cartagena. Next up, underlying criminal proceedings against undersigned counsel. As the court is aware from prior filings in this action, I've been the subject of a criminal proceeding in the Supreme Court of the State of New York. And remember, that's the trial court in New York. They just call it Supreme. But it's the trial court. It's where the trials take place. County of Kings under indictment number 75222-25, arising out of an incident on May 12th, 2025 at approximately 6:15 p.m. in front of 1242 East 80th Street, Brooklyn, New York, which houses both my law office and my residence. The same operative facts. Well, if you're worried about your safety, why did you put this information in here? The same operative facts that plaintiff has placed at issue in certain aspects of the civil action. The criminal proceeding concerned an alleged assault upon Mr. James Hunt, with Mr. Nicholas J. Palmieri identified as an eyewitness who, according to the grand jury record, intervened in and yanked Mr. Hunt backwards. I have at all times denied any wrongdoing. The dismissal of the initial indictment. On May 26, 2026, the Honorable Dale Fong Frederick, Acting Justice of the Supreme Court of the State of New York, County of Kings, dismissed the initial indictment against me pursuant to New York Criminal Procedural Law 210.35, Section 5, with leave to represent upon a finding that the integrity of the grand jury proceeding had been impaired. As reflected in the court's written decision, the impairment arose from improper prosecutorial cross-examination on collateral matters, including references to unrelated federal court proceedings and to inadmissible extrinsic civil matters, such as the email Reed Smith shared with the ADA the evening of October 14th, 2025, together with legally inaccurate representations made to the grand jury regarding service of process. A true and correct copy of the dismissal order is annexed hereto as Exhibit A. Oh, and hold on, is that... Let's see, if that's a lengthy order, we can hop over and read that. Let me look at it. And it seems like this is going to be the dismissal order for the indictment itself. So that would be end of May of this year. I think that happened. All right, let me download it. Come on. Okay. Oh my God, I have so many tabs. All right, so let's take a look at this. It's 8 pages. Oh, 14 pages. I lied. I don't know. This is, all right, single spacing-ish. It's like 1.5 spacing. All right, so let's see. Is this May what? May 26, 2026, from Judge Fong Frederick. So the defendant, Tyrone Blackburn, is charged with assault in the second degree and other related charges. The defendant moves for an order dismissing the indictment. The people oppose. For the reasons set forth below, the defendant's motion is granted. The history is that it is alleged on May 12, 2025, while the complainant, Jim Hunt, was attempting to serve the defendant with a summons and complaint in a civil proceeding, the Fat Joe case, the defendant reversed his car, struck and injured the complainant, and left the scene without exchanging information with Hunt or contacting the police, while knowing or having reason to know that Hunt was injured. On June 25, 2025, the defendant was arraigned on a felony complaint in lower criminal court, charging him with several counts of assault in the second degree and other related charges. The defendant then testified before, and I can make this bigger, before the grand jury on October 15th, 2025. The grand jury voted to indict the defendant. The defendant was arraigned on the indictment in Supreme Court on October 29th, 2025. The defendant filed the instant motion to dismiss the indictment. Grand jury evidence. The people's witness. In the grand jury, the people presented testimony from Hunt as well as an eyewitness named Nicholas Palmieri and Detective Jason Sharp. Now, Jason Sharp's going to be where we have the Giglio issues. So there's so much going on here. Hunt is a private investigator who'd been hired to serve process on the defendant. According to Hunt, on May 12, 2025, Hunt and Palmieri went to the defendant's address and observed the defendant park in his driveway and remained seated in the driver's seat of his vehicle. You know, like when you get home and you don't want to get out of your car and you just like sit there booping. Hunt went to the defendant's vehicle and waited for a couple of minutes for the defendant to exit. The defendant did not exit the vehicle and instead put the car in reverse. Oh no, Terry, what are you doing? Hunt got behind the car and tapped on it. Hunt walked to the driver's side, told the defendant he was served, and put the papers under the windshield wiper of the car. The defendant turned the wheel, reversed the vehicle, hit Hunt's left knee, and drove away. Palmieri testified that Hunt initially stood off to the left of the rear driver's side of the defendant's vehicle. Hunt approached the driver's side window and told the defendant that he was served. The defendant reversed and struck Hunt with the left wheel of the vehicle. Palmieri grabbed Hunt and pulled him away from the vehicle so it did not roll over Hunt's knee. Palmieri recorded the incident on his cell phone. Oh, I want to see that so bad. The people introduced videos of the incident. On video, Hunt can be seen moving with the vehicle as it reverses. Hunt visibly stumbles but remains standing. The defendant's vehicle pauses, and the defendant is seen to be mouthing words at Hunt and Palmieri through the closed car window. The defendant makes various hand gestures while mouthing words at Hunt and Palmieri. Hunt's injury is visibly bleeding on the side of his left knee. The defendant then drives away, and Hunt limps away. The defendant's direct testimony. So this is Blackburn. The defendant is a licensed lawyer here in the city of New York, and they cite his transcript. The defendant has been practicing law since around 2015, representing individuals who are survivors of sexual assault. So this is his testimony to the grand jury. So he's up there telling, hi, I'm a duly licensed attorney. I represent individuals who are survivors of sexual assault, and they're trying to silence me. Oh, Lord. Well, let's see. It says, as well as handling employees against their employers and survivors of medical malpractice. Prior to May 12, 2025, he'd been served 4 times in the same lawsuit, despite sending a waiver of service to the opposing counsel. On May 12, 2025, the defendant was present at the Sean Combs trial as he represented several people who testified or provided information in that trial. The defendant was harassed and threatened by people while leaving the Sean Combs trial, where people knocked on his vehicle window, followed him with phones, and yelled and screamed. He, quote, didn't think anything of it. The defendant drove from court at the Southern District of New York to his home in Brooklyn. After driving home and pulling into his driveway, the defendant stayed in the vehicle while talking to a client on the phone. While speaking with his client, he began to reverse out of the driveway to go to the store, at which point he did not see anyone near his car. The defendant's vehicle had sensors that notified him if there was anyone around the vehicle and automatically braked if it detected anything within 2 to 3 feet. The vehicle had a black box that kept records of collisions, and he had a screenshot of the black box register that showed the last time his vehicle was involved in a collision was April 25th, 2025. While the defendant was reversing his vehicle, he looked around and didn't see anyone, but he suddenly heard banging on his driver's side window and tugging on his door handle. The defendant thought someone had followed him home from the trial and screamed. When he looked out his window, the defendant saw one man holding up a cell phone and another man with something large and black in his hand. He believed the black object was a gun, feared for his life, and continued to reverse. One of the men then jumped on the hood of his vehicle and stuck something in his windshield and then jumped off. The defendant then drove 2 blocks away, pulled over to get the item that was on his windshield, at which point he discovered that it was legal papers from the lawsuit for which he'd previously been served. The defendant expressly stated that he never hit Hunt with his car. He said that he's an officer of the court and has never been arrested before, but he was taken into custody and fingerprinted. Cross-examination of the defendant. The people focused their cross-examination of the defendant on 3 topics: the incident itself, the service of the civil suit, and allegations of the defendant's purported prior attorney misconduct. The transcript of the people's examination consisted of approximately 47 questions about the incident and approximately 70 questions about service of the unrelated civil suit and attorney misconduct. So things that might not materially matter, but could sway the presentation and how the grand jury receives it. The people commence cross-examination by asking the defendant to identify himself in the video and to provide his cell phone number and email address. The people then question the defendant about the underlying incident, during which the following colloquy ensued. Question. Now, at that time, an old man approached your car? A. At that time, like I said before, 2 males approached my car. I did not know anyone's age. I couldn't tell from how they looked what age they were. The defendant stated that he never spoke with the men and could not hear their voices because he had his air conditioner on. He stated that he never saw the 2 men until he was halfway out of his driveway. He was facing backwards to reverse when one of the men ran up to the vehicle and banged on his window, at which point he'd already cleared the driveway. He thought the black rolled up object was a gun, and it was not until after he drove away that the defendant looked at the object under his windshield and learned that it was paperwork for the civil proceeding. So was it under your windshield already? During this line of questioning, the following colloquy transpired. Question. To be clear, the object that you believed he was holding, that was a gun. That's the same object that he put under your windshield wiper, correct? A. No. Incorrect. If you want me to elaborate, I can. Question. No, sir. So he had a second black object then? Answer. Could I answer? Okay. So it's not a simple yes or no that what I believed he had in his hand was a gun was stuck into my windshield. He stuck something into my windshield and I thought he had a gun. 2 of those things can be true at the same time. Question. Now, after you struck the individual with your car, you actually sat in your car for a period of time, right? On the street. Answer. I did not hit anybody with my car. Question. After an individual was struck, fair to say? A. I did not hit anyone. Answer. I did not hit anyone with my car. So I'm not just repeating it. He repeats that answer. Question. After the incident in your driveway, sir, however we want to characterize it, you sat in the street for a period of time and looked at the individuals, correct? The people inquired about the defendant having waived service of process in the unrelated civil suit for which Hunt and Palmieri had come to serve him. Referring to an email exchange between the defendant and opposing counsel in the unrelated civil suit, the following colloquy occurred. Question. Now, sir, you mentioned that you were willing to waive service of process for the civil case that was being filed against you. Is that right? Yes. But isn't it true that you were only willing to do that under certain conditions that were not agreed to? Answer. No, not true at all. And if you're referring... Question. So, and ... .. who is like also following these cases, the umbrella of these cases. I didn't see this order from the judge, but I said something on X in reply to ... .. well, wait, so they're taking issue with him arguing that he waived service, so why are they trying to serve him? But I'm pretty sure I can picture Blackburn making issue if he was never served in person. Even if he's agreed to electronic service, he would still make an issue of it. ... replied like, oh, he actually did. He did raise that issue previously. So, and then he cited something. I don't know what exactly it was. Maybe it was this. So then this transcript goes on, and the people, the ADA, the assistant district attorney, whoever it is, says, so you never emailed Joe Tacopina saying that you would only waive service if he met you at the federal DA's office? Answer. No. I said to Joe Tacopina in an email, which I don't have in front of me, but I'll be more than happy to present it to you guys, that's accusing me of engaging in acts of extortion for engaging in free litigation communications. And I said, if you believe that I extorted your client, meet me at the Southern District of New York and present your case for extortion, and I will bring my client, and he will present his case for sex trafficking, and we will see who the prosecutors arrest. And this is... If you guys remember the emails that are relevant to the April 29th filing of the Fat Joe lawsuit, there's like these communications from Tyrone Blackburn saying like, meet me down at Homeland Security and we'll discuss these allegations. Like it was just kind of a weird proposal. So, and that's a throwback. That's like one of the first streams on these umbrella cases. Mr. Prince, this is the ADA. Madam Foreperson, so that's the grand jury foreperson being addressed. At this point, I have to ask you to instruct the witness to answer the question. The witness, so Blackburn says, he asked me a question, I'm trying to answer it. The foreperson says, sir, please just answer the question. Blackburn says, I'm trying to. So ADA Prince says, I will re-ask. The condition for you waiving service was that Mr. Tacopina meet you at the federal DA's office per your email to him on May 8th, 2025. Okay, this is different then. Maybe it's in the second amended complaint. Because May 8th. All right, hold on. Blackburn's next answer says, no, because according to the April 29th email where I said to him I would waive service of process, and he responded, good. I'm happy that you would waive service of process, and attached a copy of the complaint that had just been filed. I was already served at that point. So whatever emails back and forth that him and I had after that point, I had already been served 4 times. There was no purpose for him even to continue to try to serve me. I had already been served. I have all the certification of service. It was filed in the Southern District of New York docket. Okay, so apparently there's an email from after he waived service saying, if you want to serve me, then you've got to meet me in person after he agreed to waive service. So I see why the ADA is asking these questions. So then the ADA Price says, you're a lawyer, right? Blackburn, yes. ADA Price. So you know the importance of serving process. Maybe importance? Blackburn says, of course. ADA Price. Is it a requirement to bring a law? It is a requirement to bring a lawsuit, right? Blackburn. Yes. ... Price. Process servers traditionally serve papers on people personally, correct? Blackburn. Not necessarily, no. As evidenced by the fact that they served me 4 times prior, and it was never done through personal service. Like I said before, I am a PLLC, and once you serve it on the Secretary of State, that's serving it on me. And they had already accomplished that weeks in advance, and more times, 5 times essentially, if you add the May 12th. Price says the traditional way to serve somebody is to hand them and say you are served. Everybody understands that? Blackburn. That's not accurate. And that's the end of that transcript bit. So then we've got the people then questioned the defendant about an unrelated matter he handled as an attorney where he allegedly filed jurisdictionally defective lawsuits in federal court. During this line of questioning, the following colloquy ensued. And yeah, I don't know, maybe the prosecutor felt this was relevant, like you're an attorney, you should know, but here you are not following rules. But I mean, this is why I think grand jury transcripts should be transparent, because maybe I could find a reason why this would be relevant, but I can also see why it's just kind of like you're making this person, whoever the defendant, whoever the accused is, look scummy in an area that might not be related to what the grand jury, that the task at hand is. But okay. So they say there's a number of cases where you filed federal lawsuits in the wrong jurisdiction. Isn't that correct? And then Blackburn says, if you're talking about the opinion from Judge Denise Coate in the Southern District of New York, that was a case which, if you're going to bring it up, please allow me to explain it. I'll be more than happy to. And then Price says, please allow me to ask the questions. Blackburn, ask your question. Price, now you had a case in front of her, yes or no? Blackburn, yes, I did. It lasted about 60 days. Price, and that was a case where you'd filed a lawsuit in the wrong jurisdiction. Blackburn, I filed a lawsuit in the jurisdiction that I believed was accurate in accordance with my research and in accordance with what my client provided me. Price, but it turned out to not be the correct one, right? Blackburn, and when I learned that, I withdrew it, as I'm required to do under Rule 41 of the Federal Rules of Civil Procedure. It was voluntary dismissal without prejudice, so I can refile it in state court, which is what I did. Price. Now, Judge Coate looked at some prior cases where you'd done similar things, right? Filed cases in the wrong jurisdiction. Oh, I know where this is going. I see it. I see it. Blackburn. There were, I think, about 6 cases that I'd filed. I don't have it in front of me, in the Southern District of New York. One of them I was acting as, and then it cuts off. Price says the question is just whether she brought up the other cases. Blackburn. She did, and she wasn't the judge on any of those other cases. Price. Now and she reviewed all those and issued a decision and an order in your case that you had in front of her, correct? Blackburn. She issued an opinion, yes. Price says, now in her opinion, you improperly filed cases in federal court to garner media attention. Isn't that right? So this goes to Tyrone Blackburn. So I see why in a bubble this could be prejudicial, but if you get up and testify in front of a grand jury with an opening statement posturing yourself as an advocate for survivors of violence, sexual violence it seems relevant that a judge has made, in an opinion, a judge has included an explicit comment that you do this type of thing, you file all of these cases in federal court to get the publicity. Right? It's not just pure advocacy, goodwill nature, you are the one who wants to be the voice for victims. Doing it for media attention is a little bit different from that. So I actually see why this line of questioning is relevant in the context of Tyrone Blackburn opening his testimony, describing himself the way he did. But it's also very inflammatory. Like, oh, another judge doesn't like you, so let's just indict you because we're considering that and not the facts of the case. So let's see. Blackburn says that's what she said, but not true. Price says, and to embarrass defendants with salacious allegations. Blackburn, that's her opinion. Again, not true. Price, and to pressure defendants to settle quickly. That's her opinion of you, correct? Blackburn, that's her opinion, and I don't agree with that opinion because, as is the case with any case, I pick my clients, I don't pick their facts. Clients come with facts and evidence, and you put that together, and you file the lawsuit based on the facts and the evidence as presented to you, so long as there is a colorable area of law that you believe has been violated. I'm an advocate. I advocate on behalf of individuals of sexual assaults, survivors of sexual assaults. I am a survivor of sexual assault. That's why I do the work that I do. Prince. Madam Foreperson, at this point I have to ask you to instruct the witness again. Foreperson, can you please answer the question? And then the question has been answered, sir. Answer is okay. And then question, Judge Coate referred you to the grievance committee for your conduct on all those cases, correct? And then Blackburn says she said she would, she never did. The people also questioned, this is back to the Judge Frederick Fong's order. The people also questioned the defendant about another unrelated case in which another federal judge found that the defendant filed motions with hallucinated citations. The defendant did not dispute that his motion papers contained hallucinated citations and stated that when upgrading his research tool, it used a new artificial intelligence component that hallucinated citations. The defendant testified that relying on the AI component had been a mistake, not intentional or malicious, and that he was not careful in reviewing his motion papers. Oh, hold on. We need to do the stream on the Rock Nation sanctions battle for the companion Dixon versus everybody case. Because Rock Nation's Alex Spiro's response to Blackburn's opposition filing, which we need to read, is like, hey, there's multiple hallucinations in Blackburn's opposition. And this stuff is all filed within the last week. I think Blackburn's opposition was filed on July 1st. So this is very interesting to see, like, well, here we're being given the benefit of the doubt, but we've got AI accusations again. Another one. So, man, we've got to do those streams. We've got a stream on the lawsuits that Blackburn filed, and we've got the sanctions, another sanction battle saga to cover. So... so they've got, let's see. During this portion of cross-examination, the following, I almost said the following colloquy transpired. Question, it is June 26, 2025 decision. Answer, okay, so that's the order to show cause when he asked me to come in and explain what happened. And in his October opinion, after he had made his final decision, he said that what I did was not novel and that it's a trend within the industry since the introduction of AI. And as I explained to you earlier, there were 2 federal judges who had to pull opinions because of the same thing. And then ADA Prince says, Madam Foreperson, please instruct the witness. I'm tired of reading this line. Foreperson's like, please answer the question. The witness is like, sorry. So Blackburn says, sorry. ADA Price, if you want to bring up the October decision, we can look at that also. And then Blackburn says he fined me $5,000. Question, you had to go and make arguments at an order to show cause, basically explain yourself, explain why these fabricated motions were being filed. Blackburn says to explain what happened with LexisNexis, the new program I was using. Question, now Judge Stickman, in his October 5th, 2025, I think this is the Jakes and Youngblood case, in his October 5th, 2025 opinion, said, "The court does not find Blackburn's explanation of what occurred entirely credible." Is that true? That's what he said? Blackburn says, okay. Question says, correct, yes or no? Answer, yes, that's what he wrote. The grand jury requested to see the defendant's black box evidence and the email exchange the defendant testified to for their review. However, the people instructed the grand jury that they did not have the proper foundational witness available to introduce the information from the black box or the email, and instructed the grand jury not to speculate about the black box. Well, that's interesting because they have the power. Like, why? Yep, I think that's the problem. The people should have produced this information if the grand jury requested it. But okay, apparently they didn't. I think all grand jury proceedings, I would love for the I get that you want to protect the sanctity and give the grand jurors, you know, they can make the right decisions without fear of scrutiny, and maybe there's some argument to be made to protect the accused who haven't even been indicted yet. They haven't really been formally accused if we're still bringing it in front of a grand jury. Um, but still, like, I want to know how many times people, like prosecutors, will use grand jury requests, subpoena powers of the grand jury to go get things that maybe they shouldn't be digging their nose in, getting witnesses to speak who wouldn't speak to their detectives. It's an allegation we heard Brian Steele make about Brian Sprinkle using and abusing grand jury subpoena powers in relation to the YSL case. And here we're seeing the people, Kings County District Attorney's Office, doing the opposite. Oh, even though you want it, grand jury, you are requesting this on your own accord. Information that I think is clearly relevant. The district attorney's office is like, no, we can't do that. We can't go get that for you. And I think that's bullshit. I think that's bullshit. And it shouldn't work that way. So they were told, the grand jury here was told by the people not to speculate about the black box information or what was contained in the email. Yet they were able to say what they wanted to about the emails. The grand jury returned a true bill. So they indicted. This is the analysis. The court may dismiss an indictment that fails to conform to the requirements of Article 190 of the Criminal Procedural Law when the error rises to such a degree that the integrity of the grand jury proceeding is impaired and prejudice to the defendant may result. Dismissal of an indictment pursuant to CPL 21035, Section 5 should be limited to those instances where there is prosecutorial wrongdoing, fraudulent conduct, or errors that potentially prejudice the ultimate decision reached by the grand jury. I mean, yeah, if they want to see something that goes to the nature of a collision. Although the statutory test is precise and very high, it does not require actual prejudice, but rather that prejudice to the defendant may result. Improper hearsay elicited in the grand jury may be considered a defect, but will generally only be deemed fatal where the remaining evidence is insufficient to sustain the charges. Not every improper comment, elicitation of inadmissible testimony, or impermissible question will render an indictment defective, nor will isolated instances of misconduct automatically rise to the level that the possibility of prejudice will ensue and impair the integrity of the proceedings. Rather, the likelihood of prejudice turns on the particular facts of each case, including the weight and nature of admissible proof adduced to support the indictment and the degree of inappropriate professional influence or bias, and where irregularities in presenting the case to the grand jury rise to the level of impairing those proceedings and creating the risk of prejudice. Where such irregularities exist, the indictment cannot stand, even if supported by legally sufficient evidence. The people have broad power and duties, as well as wide discretion in presenting their case to a grand jury. The people must exercise impartial judgment and discretion in providing both legal instructions to the grand jury and determining what evidence is presented or excluded. However, this discretion is not absolute. So here's the big problem. So even if the court can find here that the accusations you want to levy against Mr. Blackburn, court may find that, yeah, there's legally sufficient evidence. You can't just do whatever you want. As the grand jury's legal advisor, the people perform the dual function of investigating criminal activity to determine if charges are warranted and protecting individuals from needless or baseless prosecutions. The people are charged with the duty not only to secure indictments, but also to see that justice is done. I think this part is often forgotten. Oh, and that is my pet peeve. This part. This part's always forgotten. Oh, maybe we need two colors. Highlight it. Say it louder for the prosecutors in the back. With great power comes great responsibility. How do I turn off this highlighter? All right, there we go. I don't deserve the power of highlighters on stream. With great power comes great responsibility, including the people's duty of fair dealing. The people may not act as an unsworn witness by expressing their own personal beliefs on matters which may influence the jury or suggesting the existence of facts not in evidence. Uh-oh. Such conduct violates their duty of fair dealing and impairs the integrity of the grand jury when it rises to the level that prejudice to the defendant may result. The examination of the defendant. So now we're getting into the stuff we just cited, how it relates to what's in front of me, what's on the record. The examination of the defendant. In oral arguments, the people conceded that the grand jury's determination in this case would be based largely on the grand jury's evaluation of the credibility of the main witnesses, Hunt and the defendant. Here, the people's cross-examination focused mostly on efforts to attack the defendant's credibility. Their questions on cross-examination involved instances of improper characterization of Hunt as an old man, belittling the defendant for not acquiescing to the people's characterization of the allegations, as either the defendant striking Hunt with his vehicle or that an individual was struck with his vehicle. Unfounded assertions that the defendant was not credible because he filed papers in the wrong jurisdiction in federal court, despite the absence of any judicial hearing or disciplinary committee finding of attorney misconduct, and even where there was a judicial determination of misconduct for filing legal papers with hallucinated citations that went to credibility, the people improperly characterized the finding to imply that the defendant intentionally fabricated citations. The people's cross-examination of the defendant was improper. So, sub-argument here, improperly filed federal suits. While not all hearsay evidence will render an indictment defective, here the people introduce allegations that the defendant had a pattern of intentionally filing court pleadings in the wrong jurisdiction to gain media attention, tactical advantage, and embarrass litigants. This hearsay was not introduced by a sworn rebuttal witness or admissible documentary evidence, but rather by the people as an unsworn witness and was presented for its truth. This inappropriate prosecutorial influence was not just an isolated instance of improper questioning, but part of a pattern of questions that encompassed more than half of the people's cross-examination. And again, this is a great reason. Put some transparency forth with grand jury proceedings, and maybe some of this improper conduct by prosecutors would be deterred. More troubling, it gets worse, was that the hearsay regarding the improper filing of civil suits did not address the credibility of the defendant. Indeed, there's no evidence that the federal judge made a finding of misconduct, only that the federal judge intended to refer the conduct to a disciplinary committee. There was no evidence that the federal judge sanctioned the defendant or that the conduct was ever referred to a disciplinary committee, and the committee made a finding of misconduct that went to the defendant's credibility. Under these particular facts, the introduction of the hearsay constitutes an improper prosecutorial influence that rises to a level that impaired the grand jury function and may have prejudiced the defendant. The service of process. The people also erred, and I think I remember reading this argument. I feel like I saw bits and pieces of this. Maybe ... /star posted like screenshot snippets. But I don't remember reading the full thing. But I feel like I remember this. The service of process. The people also erred by questioning the defendant about the contents of emails regarding service of process in the unrelated civil proceeding. This was compounded by the people instructing the grand jury that they did not have the proper witnesses available to introduce the emails after the defendant testified that he could provide them to the grand jury if they wanted to review the emails. There's also no indication that the people made any effort to obtain the proper witness to introduce the documents, despite the grand jury request. And again, like, if that forgotten part, that part of your duty and part of the reason prosecutors have discretion is to pursue just outcomes. And we always forget that part. We always seem to forget that part. If these emails are relevant, why would we not want to pursue them? It goes on. In any event, this hearsay was introduced by the people and was presented for the truth of the matter asserted, but had no bearing on the defendant's credibility as presented. In their failure to lay a foundation to impeach the defendant, the people conceded that the defendant waived service, but that the waiver was conditional. This distinction had no probative value and only served to mislead the jury and potentially prejudice the defendant. Indeed, from the questions asked, it was clear that the people, the legal advisor to the grand jury, was unfamiliar with the law concerning service of process on an individual. Man, I would love to see call-outs like this more often. And like, I feel like the only reason this is available is because it's become relevant in other proceedings. Um, it's New York dockets are not very accessible publicly. Like maybe if you're an attorney, you could go in and see things that I can't. But a lot of these state proceedings, if it's like a federal court in New York, you can go through Pacer as a member of the public. But I I don't know, maybe I'm missing the way to go and like pull the order from this case, but I did not find a way that without like going to the court in person and requesting a copy that I could obtain this. So I would love to see this more. I would love for it to be more accessible because I think this type of embarrassment is the best deterrent. Like ADA Price, we just read him on a stream. We talked about it a bit on X. Some other people have talked about this decision on X and the prosecutorial misconduct underlying the decision to dismiss the indictment. Like, I think that's a great deterrent. If you are in the shadows, there's no possible worry or concern about humiliation, embarrassment, being scolded. If worst case scenario, a case is dismissed, but do you really care? As long as you're not embarrassed, you'll still get more cases to work. But maybe that embarrassment, the sunlight, could be the best deterrent. And I could go on. You guys know my rants about transparency. So they say that instead, the people impermissibly inserted an inference that is not grounded in fact or law, that everybody knows the traditional way to serve process is to hand papers and say you've been served. While this may be true on television. Oh my god. All right. It took me a minute. I'm delayed on the reaction here. Why isn't it letting me pull up the flames? There we go. He's cooking. He's cooking. StreamYard isn't playing nice with me. While this may be true on television, it is not the law in New York State. By introducing this misleading evidence, the people again became an unsworn witness by inserting their own beliefs into the proceeding instead of presenting admissible evidence to impeach the defendant's credibility regarding a denial of service of process, and through their improper influence, mislead the grand jury on a legal standard. In doing so, the people failed to exercise impartial judgment and violated their duty of fair dealing. Moreover, the grand jury's request to review the email indicates that the grand jurors did consider this line of questioning. Yep, it was relevant enough for them to think to ask about it. So they considered this line of questioning as germane to their decision, and therefore it may have resulted in prejudice to the defendant. I'm not sure if this is so helpful for the civil suits that Tyrone Blackburn's brought forward, because it seems like the issues with the indictment, and maybe there's more that will come out that doesn't relate to Kings County District Attorney's Office, and it relates to TMZ and Joe Tacopina and whatever. But this to me doesn't seem like a clear-cut decision from the judge, like, hey, these people are scheming and scamming on you to bring this malicious prosecution forward. It seems more like the conduct that the government's engaging in, their line of questioning, in and of itself, was improper and prejudiced the grand jury outcome. Or may have prejudiced, because you only need to meet the may have standard. So, what a time. What are you guys saying over here? Kristen's like, I'm still here. I'm just lost. I mean, this case is taking us into the weeds because there's just so many layers that intertwine. Like, we have so many actions, different cases, so many cases, names, parties, dates and times. We have like a dozen sanction motions to keep track of. Just crazy. Crazy. Yeah, New York sucks for that. I agree. Love New York, but they definitely suck for this. Adventure Aaron says, I'm glad the court is scolding the prosecutor for this. This is exactly what I mean when I say, like, think of somebody that you might not think is great, that you might not think is innocent, that you might not think is moral, whatever. Not the person that you want to root for the sake of seeing them win and them specifically succeed. Think of somebody like that. I have great skepticism towards Tyrone Blackburn and what I would call his antics. That's my opinion of him. But this, I think, is a phenomenal outcome if this is how the underlying grand jury proceedings were occurring. And that's what I mean when I say think of, and I get this from Sean Martin from Potentially Criminal, like, you want the system to protect the people you don't like. You don't want this means to justify the end because you don't like the person that's receiving a bad end result for them. Like, you need the system to work for the bad people, or it won't work for the good people. And the bad or good is subjective. The system's supposed to get us to the truth. And could a system like this, it's like, oh, we don't want to get the black box. Oh, we don't want to let you see these email proceedings that we're the reason those emails were even suggested in an answer, because we asked a question that elicited that answer. But we don't want to go get that information for you, even though you're asking for it. Is that the way to finding the truth? And without a pursuit of the truth, can you have faith? Can you believe that the process will bear a just outcome? And all I can say to add on, I totally agree, Adventure Aaron. I'm glad the court is scolding the prosecutor for this. If this happens more than I'm aware of, I would love to be aware of it. I would love to see this more. If it isn't happening, it should happen more. And if it is happening, I wish it would be more publicly available, because I think it would, like, people want to do good work when they get applauded for it. Sticks and carrots. Punitive actions, sanctions aren't the only way to deter bad behavior. Rewarding good behavior, or wanting to be on the receiving end of something that's positive and not a scolding from a judge, is a great motivator of good prosecutorial work. So yeah, I'm glad that this was included. And again, I'm pretty sure when I say .. /star, that is their username that they use when they, sometimes they're on YouTube, but usually I mean something on X. When I say .. /star, I'm referring to a person who follows these cases. I do think they provided some screenshots of either this order or maybe just the transcripts, the line of questioning. I'm not sure what they were looking at, but I'm glad to see the full, what the judge is doing here. It's a time. It is a time. Ah, Susanna's at the beach. Take us with you. We're all at the beach with Susanna. I hope you're having a great time. Next, we've got the AI hallucinations. The people, and I think this one's interesting because we seem to have more coming to light about this, but I mean, the judge is relying on what they have available, and if the prosecutor was making a reach of something, they were making a reach of something. So the people's questions regarding the federal court's findings that the defendant was not entirely credible was an appropriate cross-examination subject. This subject matter was based on a judicial finding, after an order to show cause, that bore directly on the defendant's credibility. However, it was improper for the people to question the defendant on the underlying facts regarding the use of AI when that information itself was irrelevant to the defendant's credibility. The evidence before the grand jury was the defendant's response to the order to show cause was not entirely credible, and not that the defendant intentionally fabricated citations. The people should have simply asked if the federal judge had sanctioned the defendant after finding that his response to the legal issue were not credible and presented admissible evidence to complete the impeachment if the defendant denied the finding and sanction. Standing alone, this error would be insufficient basis to warrant the drastic remedy of dismissal, but when taken in conjunction with a largely impermissible cross-examination, it lends further support to the potential of prejudice to the defendant. The totality of the people's cross-examination of the defendant undermined their duty of fair dealing and may have impaired the grand jury's fact-finding process. While the people provided some curative and limiting instructions during the proceedings, The cumulative impact of the people's improper questioning on issues of credibility impaired the integrity of the grand jury proceedings and may have resulted in prejudice to the defendant, thus warranting dismissal of the indictment. Under the facts presented, the motion to dismiss the indictment is granted on these grounds. So, there you go. They're going to go with the notice of the scope and grand jury presentation. The people are not required to provide notice to a defendant regarding the expanded scope of the grand jury proceedings. Once the people have notified the defendant that the charges in the felony complaint would be presented to the grand jury, the people have satisfied their statutory obligation. Here, the people met their statutory obligation with the felony complaint. The charges in the indictment involved the same complainant and incident contained in the felony complaint, and the defendant should have been aware that the nature and scope of the grand jury's inquiry could lead to less or more serious charges. Since the people satisfied their notice obligation, the motion to dismiss is denied on those grounds. So we're just going through what we're not granting for. We are specifically granting for the above reasons, the totality of the cross-examinations and the issue of fair dealings. The exculpatory information. The defendant argues that people failed to present exculpatory evidence to the grand jury. I don't think that's required of grand juries, and I really wish it was a requirement. That's why grand juries, they can indict ham sandwiches, whatever the saying is. We need to update that to something more exciting in the year of 2026. They would indict blank, just something besides a ham sandwich. Sandwiches are expensive. Sandwiches have gotten very expensive these days. I take issue with that. But here, one of the grounds raised in the motion to dismiss must have related to the failure to present exculpatory evidence to the grand jury, specifically that they didn't play the entire surveillance videos, that they didn't present Hunt's medical records, and that they didn't present affidavits of service, which showed Hunt's ability to work in the days after the incident. The people are not obligated to disclose all evidence in their possession that is favorable to the defendant or to instruct the grand jury as to every possible defense suggested by the evidence at the grand jury stage. The integrity of the grand jury proceedings was not impaired by the people's decision not to present any of the evidence challenged by the defendant. So the motion to dismiss the indictment is denied on those grounds. Justification and assumption of the risk instructions. So another ground raised. When viewing the evidence presented to this grand jury in the light most favorable to the defendant, the people were not required to charge the justification defense in this criminal action. Indeed, the court is hard-pressed to see the validity of this argument. Okay, so we're going to argue at, I don't know if this was Heather Palmer already filing, because I think the motion to dismiss was first filed back in October of 2025, and I'm not sure, I think she did file a notice of appearance right away in the case. But whoever filed this, they're not escaping from this judge's criticism. This judge, if he's got something to say, he's gonna get it off his chest, it seems. Oh my gosh. So he says, the court is hard-pressed to see the validity of this argument where the defendant is alleged to have been inside of his vehicle the entire time leading up to the alleged collision with Hunt, who was a pedestrian, and the defendant claimed he did not even know Hunt was present. Furthermore, the defendant repeatedly denied striking Hunt with his vehicle. Since the use of physical force is a necessary component of the justification defense, the evidence does not support the need for the grand jury to make a determination regarding justification or appropriate use of force. The charge of assumption of risk is inapplicable. The motion to dismiss is denied on these grounds. And again, another reason I think this should be transparent, decide for yourself, is when this dismissal came down, the screenshot that, maybe I can just pull it up. Let me see. Sorry, Instagram is always stupid to pull up on a computer. Oh, since we're going, I forgot this was on. I just like, let me make this bigger before I pull it up because it looks really stupid on my screen. Okay, let's try this. save, do a screenshot. Since we're here anyway, I forgot that this was saved on, this was posted on the Instagram handle titled Tyrone_Blackburn, who we're not sure who this account belongs to. But I forgot that there's this post up. So we mentioned earlier in this stream, going down to the Homeland Security, and this email's in here. It's dated May 1st. So it would be after the 29th that we heard them ask about in the grand jury testimony. But it says, "Good morning, Joe." This is from Tyrone Blackburn. "I'm following up on my previous email. What day would you like to meet me at the Southern District of New York so you can present your case for extortion and I can present my case for RICO and sex trafficking? We can have a conversation with federal prosecutors and Homeland Security investigators. I plan to fly in from Florida for the start of the Diddy trial, but I'm willing to come today if you want to meet with the Southern District of New York and Homeland Security tomorrow. The latest flight to New York is 8:40 p.m. Let me know." Now, I saw this because I wanted to read it because we mentioned it, and I don't want you guys, if you haven't been following this, to think I'm crazy by just throwing it out there that Tyrone Blackburn said something like, "Come meet with Homeland Security. I can set that up for us." Kind of just like an outlandish thing. And rather than going back through the documents, I just, whatever, let it fly. You either believe me or you don't. You can go back and watch my old streams, but it's right here. And even funnier, like the idea that, I don't know, if you take issue with this, but you have this as a pinned post, it's his first pinned post on this Instagram account named Tyrone_Blackburn. I mean, are you really that concerned about your security if you're advertising where you're going to be? I don't know. But whatever. It's a pinned post. That wasn't the one I was opening up the Instagram for. I was actually trying to open this other one, the statement, and Heather Palmore posted it to, I don't know if it was her own page or her law firm group, but Tyrone Blackburn posted one as well. One was a blue background, one was a red background, but I think the text was the same. And it was this. "So today, a Supreme Court justice in Kings County dismissed the felony indictment against Mr. Blackburn after ruling that the integrity of the grand jury presentment by the Kings County District Attorney's Office was impaired." Valid. I think that's fair. "From day one," this is highlighted, "Attorney Blackburn has maintained his innocence, and this dismissal today is crucial not only for Attorney Blackburn, but for all members of the community at large that seek fairness and proper due process." I agree with that part. Fairness and proper due process when facing charges that impact one's lives, family, and career. Attorney Blackburn will continue to be a voice for the voiceless and to advocate for women, men, and children that have been sexually assaulted and abused. Heather Palmer, attorney for Tyrone Blackburn. No, which is kind of what I expect for any PR battle. This implies that it was dismissed on the basis of like sufficiency of the evidence. I don't know. We still got some more motion to read, a little bit, a few sentences. Is that really why we had this dismissal? I agree with the fair process and due process characterizations. That is very much what the judge is relying on here. But what else we got? We got a tiny conclusion. Do we have something about the sufficiency of the evidence? Do we? I don't think so. Because what does this say? Well, I see the word sufficient. "The evidence presented by the people to the grand jury, when viewed in the light most favorable to the people, was sufficient." So to me, I think that press release, I don't think this is an improper characterization meant to make the public infer that a judge decided that there wasn't sufficient evidence to even bring the charges, that not even a grand jury who would indict a ham sandwich would indict Tyrone Blackburn. And I don't blame them for playing this game, but this is an argument for the transparency, that it should be easier to get a hand on these orders so you can read it for yourself and decide for yourself. And for me personally, I would say even objectively, that it's in the written order here that this judge said that, all right, well, it would have been sufficient to establish the offense charges, at least at this stage, the grand jury presentment. and that the issue was that we had this improper cross-examination of the defendant, and that impaired the integrity of the grand jury proceedings to such a degree that it may have resulted in prejudice, and the indictment cannot stand even though otherwise sufficient. So accordingly, it is hereby ordered that the indictment is dismissed with leave to represent, and then no true bill was returned the second time around. This constitutes the decision and order of the court. So I think it's stronger that we don't have a true bill returned the second time than to make this statement. He's always maintained his innocence. Fair enough. But don't say that in a way that alludes to a insufficiency being the basis for the dismissal. But that gets us back to the affidavit. It was this one, right? Got a lot of things going on, a lot of tabs. So many tabs. All right, so I think we were here. And it's fairly characterized here. He's not, in this affidavit, he's not saying it was dismissed because I'm innocent. He's saying that they found issues with the prosecutor's cross-examination and statements. Now the second grand jury. This is where we could get into sufficiency. On or about June 18th, 2026, upon representment, a second independent Kings County grand jury dismissed the matter, declining to return an indictment against me on any charge arising from the subject incident. The Office of the Kings County District Attorney has confirmed that disposition in writing. The criminal matter against me has accordingly been terminated in its entirety. And they attached just the paper saying that the matter's closed. Now, unlicensed private investigator dispatched by plaintiff's co-counsel. Now, so the idea is if you're going to hire someone to do something, they should be licensed to do it. What happened here? On May 12th, 2025, Mr. James Hunt, aka Jamie Hunt, or I think, didn't they say Jim Hunt in the grand jury transcripts? Purporting to act through the Hunt Group, LLC, appeared unannounced at 1242 East 80th Street, Brooklyn, the location that serves as both my law office and my residence, accompanied by Mr. Nicholas Palmieri. On May 20th, 2025, Mr. Hunt executed and caused to be filed in this action an affidavit of service, in which he represented under oath that he is a licensed private investigator in the state of New York, acting through the Hunt Group, LLC. Based on my direct communications with the New York State Department of State Division of Licensing Services, the licensure record for the Hunt Group LLC reflects the following. A first private investigator license with an effective start date of January 14th, 2023 and expiry of January 13th, 2025. And a second private investigator license with an effective start date of February 13th, 2026 and a renewal date of 2028. Do we have a gap between January 14th, 2025 and February 12th, 2026? 13 months that encompasses the May 12th encounter at my home and law office and the May 20th affidavit, as well as the October 14th grand jury testimony. The Hunt Group LLC held no active private investigator license reflected in the Department of State's records. A summary timeline cross-referencing the licensure record against the affidavit is annexed here too as Exhibit C. So we're going to take that at face value. And we'll look at those documents when we look at the civil lawsuits. What's interesting here, though, Blackburn's going to lean into, look, another court may have said that could have used hallucinated things in a filing, but I didn't mean to do so. I wasn't aware that they were hallucinated. I wasn't aware that this LexisNexis program would do that. Oops. I don't know. Could the same be said here? Could the same be said here? The conduct of Mr. Hunt on May 12, 2025 constituted on its face a violation of New York law. The New York General Business Law, Section 70, subsection 2, makes it unlawful for any person, firm, limited liability company, or corporation to engage in the business of private investigator or to hold itself out as being able to do so without first obtaining a license from the Department of State. General Business Law Section 70, subsection 4 provides that any violation of Article 7 is a Class A misdemeanor. On May 12, 2025, when Mr. Hunt appeared at my home and law office purporting to act as a private investigator on behalf of the Hunt Group LLC, and again on May 20th when he swore in a filing that this action that he was a licensed New York PI, and on October 14th when he testified before the Kings County grand jury. The Hunt Group LLC held no active license. Plaintiff's co-counsel dispatched and utilized the unlicensed investigator upon information and belief. So here he's not saying he has personal knowledge of this. Just upon information and belief, the Hunt Group LLC, Mr. Hunt, and Mr. Palmieri were retained, directed, and dispatched to my home and law office by Reed Smith LLP and Ian M. Turetsky, plaintiff's co-counsel of record in this action in connection with this litigation. Reed Smith LLP and Mr. Turetsky knew, or in the exercise of reasonable diligence should have known, that the Hunt Group LLC did not hold an active New York private investigator license on May 12, 2025, or on May 20th, 2025. They nonetheless caused Mr. Hunt to approach me at my residence and law office, and thereafter caused his affidavit, which affirmatively represents license status, to be filed in this action at ECF number 20. And maybe we should just look at this. Because I don't know, is it different if, can you have a license as an individual? And would the issue just be that he represented under the LLC and didn't represent his own license, but did he have an active license? Exhibit D. Okay, Exhibit D. We have it crossed out, State of Florida, County of Palm Beach. I, James Hunt, being duly sworn, say that I'm not a party to the action. Where do we have it? I'm a licensed private investigator in the state of New York. That sounds like an individual. All right, and then there was also service by Vincent Mineta, who did service by certified mail. Yes, I don't know. I don't actually know the specifics of how that works. Like, can you be licensed as an individual and then have like a company that has a license of its own? And if one is expired, is that problematic if you're still individually? Because it seems to me in that affidavit, he was just representing individual licensure. I don't know. I mean, if there's a way to dispute that, I'm sure we'll see that pointed out in a response to this. Because it seems to me like they're saying that it's the Hunt Group LLC specifically that didn't hold an active PI license. So anyway, they're saying that they, meaning Fat Joe's counsel, Reed Smith specifically, Ian Turetsky specifically, that they caused Mr. Hunt to approach me at my residence and law office and therefore caused his affidavit, which affirmatively represents license status, to be filed in this action at ECF. And it's just interesting to see. I think it's interesting. If you want to make a due diligence argument, you should have done your due diligence. Now you're making due diligence top of mind for me. And I'm thinking about, did you do your due diligence before not even filing your June lawsuit on behalf of Terrence Dixon against Fat Joe and everybody? But did you do your due diligence before you sent friendly letters to talk, demand letters, pre-litigation demands to Fat Joe's team before April 29th of 2025 when Fat Joe filed his lawsuit against you and Terrence Dixon. Because now you put due diligence top of mind. But okay. Yeah, don't not do your due diligence. Hey, Justice, good to see you. Oh, good to see you. Man, we've got the fabricated vehicular assault narrative and the coordinated media ambush. Hopefully I'm not named in this one, because previously the belief was, because someone didn't do their due diligence, the belief was that somehow I had stuff specifically delivered to me. Complex was accused of the same, even though Complex and myself both, I think pretty apparently, relied on what was publicly available. And I say that because that's what Complex stated in their article, and because often on stream, I do this with you guys. So if I'm doing this, what does this mean? Does this look like a hand-delivered, personalized correspondence between myself and any attorney of record? No. But here it seems like we're going to get into another claim of a coordinated media ambush. And maybe that is the case. Maybe that is what actually happened with what's about to follow here. But I'm going to let you know now, I am speaking from a very biased position on this type of argument coming from Tyrone Blackburn because he's made a previous representation to the court of a coordinated media ambush involving myself, which was not true at all. I think it was baseless and easily disproven to anyone who took 2 seconds to think about it. So I'm going into this argument like very skeptical, just so you guys know. So form your own opinions. So they say here, following the May 12th, 2025 encounter, a false narrative was communicated to law enforcement, and ultimately to a Kings County grand jury, namely that I had struck Mr. Hunt with my vehicle, run him over, or fled the scene in a manner constituting vehicular assault. That narrative is false. It is directly contradicted by Mr. Hunt's own sworn affidavit of service filed at ECF number 20, which is what we just looked at, which describes me remaining inside my vehicle with the window closed and papers being placed under the windshield, and which contains no allegation whatsoever that I struck, injured, ran over, or assaulted Mr. Hunt with any vehicle. It is further contradicted by the June 11th, 2026 Mercedes-Benz vehicle diagnostic, which confirmed that no collision event was logged on or about May 12th, 2025. You know what I think this opens us up to? If Paul Mary has a cell phone recorded video of this going down, and it doesn't show this, I would think that you'd want to, I mean, Blackburn, if he was at the grand jury presentment, should be aware. I mean, he was the defendant in that case. He should be aware of the cell phone video. Wouldn't you want to produce that here? And if it doesn't show something consistent with what's being argued in this affidavit, what's being represented in this affidavit, maybe that opens the door to anyone who wants to respond to these matters. And this is the motion to withdraw. But in the litigation, the separate lawsuits, I feel like we're eventually going to see that cell phone video. Right? Maybe not for the purpose of this withdrawal issue. But for those 3 lawsuits that Blackburn has filed, I think the cell phone video would be very relevant. So I said earlier, oh, I want to see that video. I think we might get that. Eventually. So anyway, I digress. So they say that they've got this vehicle diagnostic which confirmed that no collision event was logged on May 12th. June 19th, 2025, the TMZ call. Okay, so this is not like right away. Yeah, there's a gap in time here. So on June 19th, 2025, the same day I commenced my civil action against plaintiff, at approximately 7 p.m., I received a telephone call from a reporter identifying himself as Jacob, calling from TMZ. He informed me that there was an active arrest warrant out for my arrest, but could not share what the underlying allegations were. At no point prior to that call had I been contacted by the NYPD, by any prosecutor's office or by any law enforcement agency of any kind regarding a warrant, an investigation, or a pending charge. That doesn't mean it wasn't there. So, New York, they're like kind of special about the way they do this. What we might commonly refer to as a warrant or even an appearance ticket, depending on the nature of the charges, the NYPD issues things called an I card, which I think is often used interchangeably with a warrant, but it can be a little bit different. It kind of puts everybody in the system on alert that, hey, there might be an appearance ticket coming down, might be a warrant, depending on how it's classified. And news media is frequently tuned into those things. There was a big information war in the Jonathan Majors case because Elizabeth Rosner reported that there was an I card out for the arrest of Grace Jabari, the accuser, the then mostly unnamed accuser of Jonathan Majors. And major outlets, Variety, I think Rolling, like 3 major outlets, reported that that was not true. And they were like disputing the reports of such a thing. And lo and behold, Elizabeth Rosner, who, did a lot of great reporting for an outlet called The Messenger, which is now defunct. Now she writes for several other outlets. She stood both feet down. And lo and behold, a few days later, there's pictures of Grace Jabari leaving the 3rd or 10th precinct after making her appearance. So they do these things called I cards, and the media, whoever's in charge of looking for things about possible celebrity or high interest arrests, they do come across this information very quickly. So I'm also skeptical about this representation that just because you yourself didn't know, and if I remember correctly, there was testimony in the Jonathan Majors trial. Grace Jabari was asked about this, and she found out. She texted, she had the cell phone number of the ADA that prosecuted Jonathan Majors. I forget her name. But she had the text number, the cell phone number, even though she already had counsel. There was testimony, a line of questioning about this communication where she texted the ADA. This was in Manhattan, the Supreme Court of New York, Manhattan. Saying something like, what's going on with this? Because she heard about the news of her arrest through the media outlets, through this reporting, and didn't hear of it directly. So this is not uncommon that you might not know that the police are looking at you. They are interested in you. You might not know before the media finds out. So I don't put much weight into this. I don't think that this is a good basis to say in and of itself that the only way to explain this, or even that the likely way to explain this, is that there's some scheme, deep coordination between the process server, the attorneys for Fat Joe, and TMZ. So I'm actually really interested in seeing those lawsuits play out. No, this is a hot mess, and I'm making it more of a hot mess. Because New York has very special things. Like they have I cards, they call their trial courts the Supreme Court. Like they just make it complicated for no reason. And then we've got all these messy layers from the case itself. So anyway, point being, Tyrone Blackburn saying here, well, I didn't know, but someone from TMZ was calling me and saying there was an active arrest warrant out. And do you think if he was contacted, do you think the TMZ guy, if someone was trying to give him the tea, and that it didn't come from just like a report going out, that the TMZ guy wouldn't know what the allegations were? Maybe he just wasn't willing to say it. But anyway, he says that at no point prior to that call had I been contacted by the NYPD, by any prosecutor's office, or by any law enforcement agency of any kind regarding a warrant, an investigation, or a pending charge. They don't move that quickly. So I don't know. I don't think this is enough to get us to this leap that there was this great coordinated media ambush. But okay. And then they say the unverifiable warrant. Following the TMZ call, I immediately attempted to verify the existence of the warrant. Yeah, and if you aren't following the way iCards are initiated and by what precinct, the person who answers your call might not be able to direct you. What? What the heck is this? Following the TMZ call, I immediately attempted to verify the existence of the warrant. I contacted prosecutors, colleagues, and classmates of mine currently employed by the Kings County District Attorney's Office and contacts within the NYPD. None of them were able to locate a warrant for my arrest in any accessible system. All right, who are these people and what were their responses? June 25th, 2025, the pre-processing media link. All right, so now we're moving from 19th to June 25th. On June 25th, 2025, at approximately 5 a.m., I was arrested in Brooklyn. Before I could be fingerprinted, arraigned, or otherwise processed into any public arrest system, Mr. Tacopina appeared on TMZ discussing my arrest and stating publicly that I had mowed down a 66-year-old process server and had committed felonious assault, a statement that is false, that is inconsistent with the contemporaneous sworn record filed by Mr. Hunt himself, and the one that we just looked at, exhibit whatever, and that could not have been made by a person acting on public information alone. The grand jury, quote, investigation was a 5-page exercise conducted by a single officer 2 days after Reed Smith's ex parte collusion email transmission. On October 16th, 2025, 2 days after the October 14th, 2025 ex parte email from Reed Smith LLP to ADA Salvatore Prince, the sole law enforcement witness to appear before the Kings County grand jury was Detective Jason Sharp, shield number 3276 of the 69th Precinct Detective Squad. Hilarious. A true and correct copy of Detective Sharp's grand jury testimony is annexed here too as Exhibit F. So let's take a look at that. All right, so October 16th, 2025. And also, I mean, ex parte in and of itself isn't necessarily anything improper. The question would be, was this disclosed? Was this information disclosed? So, all right. Good morning, detective. Good morning. If you could put, who's doing the questioning? ADA? Okay, so only, well, I doubt this is the district attorney himself doing it. So it's probably Prince again. So I think this is ADA Prince doing the questioning. Good morning, detective. Good morning. If you could please state your name, Shield Command. Jason Sharp, Shield 3276 with the 69th Detective Squad. How long have you worked for the NYPD? A little over 21 years. How long have you been a detective with the 69 Squad? January will be 11 years. And what are your duties and responsibilities as a detective with the 69 Squad? Investigate all sorts of complaints that come into the precinct. It can range anywhere from petty larceny to homicide. Did there come a time where you were assigned to investigate an alleged assault that occurred on May 12th, 2025, in front of 1242 East 80th Street? Yes. As part of your investigation, did you speak with any witnesses? I did. Who did you speak with? James Hunt. As part of your investigation, did you have an occasion to collect video? I did. Where did you collect video from? 1240 East 80th Street. Where is 1240 East 80th Street in relation to 1242 East 80th Street? Okay, so this seems like it's different than whatever Palmieri recorded on his cell phone. This seems like some type of surveillance, ring camera, who knows, affixed nearby. Or next door maybe, because it's an even street number. So 1240 East 80th Street, it's like a building with attached homes. So basically you'll have one wall that's part of 1242 and 1240 residents. Yep, side by side. So 1240 is basically the next house over. But to be clear, 1240 and 1242, are they a part of the same building? Yeah, they're attached. So how did you go about collecting video from 1240 East 80th Street? I knocked on the door, identified who I was. I explained to the owner of the residence the cameras that I observed, asked him if we could look at the cameras. He invited me in. We observed the cameras and I downloaded the footage. Maybe this is him sitting in the street. Now, when you downloaded the footage, did you have the opportunity to observe a live feed on the video player? Yes, I did. Was the time that was displayed on the video surveillance accurate to real time? It was not. How off was the timestamp? The timestamp on the video itself from 1240 East 80th Street was approximately 1 hour and 6 minutes slow. When you say 1 hour and 6 minutes slow, does that mean it's behind real time? Yes. So to obtain the real time using the timestamp on the video, how would you go about doing that? So he says he observes the live footage, observe the date and time on that. I then compare it to my New York PD department phone, which has the live time on it, the accurate time, and then I do the math from there. ADA prints. I'm going to publish Peoples 1, specifically the 3 video files contained within the folder labeled Video Surveillance, 1240 East 80th Street. I'm going to start with the first video. So they play and pause. So we're paused right here at the beginning of the first video. Detective Sharp, can you see the frame here on the wall? I can. And the date that's depicted at the top of the frame, is that accurate? Yes. And the time displayed, is that the time that you said had a discrepancy, about 1 hour and 6 minutes? Yes, that's the time discrepancy. When the time depicted here is 5:09 p.m., what would the actual time be? The actual time would be 6:15 p.m. Mr. Prince. I'm going to now play the first file. The first video had been played in its entirety. So they play a video, and then they stop a video. Now I'm going to play the second video. Play it, and then the video stops. The second video was played in its entirety. I'll play the third and final video. So video's played, and then the video's paused. ADA prints. I've paused the third video at 1 minute and 7 seconds. Now closing out the video, whereupon the video is stopped. Now, detective, did there come a point in time in your investigation where you arranged 6 photographs? Yes. Was Tyrone Blackburn's photograph placed within those 6 photos? It was. In what position was his photograph placed? And number 4. And was James Hunt given an opportunity to look at that series of photographs? Yes, he was. I wonder what this looked at like. Like, did they just use like an Instagram photo of him? Surveillance photo? Because surveillance would be improper because it would put him in the location where you're asking someone to identify something that happened at that location. So, like, what photo did they use? But yeah, they said Hunt looks at the photographs. Now, was an arrest ultimately made in regards to this investigation? Yes. Who was placed under arrest? Tyrone Blackburn. And when did that take place? I remember June 25th. Of this year, sir? Yes, of this year, 2025. I have no further questions. Thank you. Thank you. So that is the end of that. Let me find the tab I had the affidavit open on. Somewhere here. Oh, driver's license photo, duh. Duh. All right, so this was... Okay, we were here. The substance of that testimony is contained on transcripts pages 6 through 11. On the face of Exhibit F, which is the transcript, Sharp's grand jury testimony, the following is undisputed. 1, Detective Sharp identified only one witness with whom he had spoken, James Hunt. 2, Detective Sharp collected video from a single source, the neighboring residence at 1240 East 80th Street, timestamp on which was 1 hour and 6 minutes off from real time. 3, Detective Sharp did not interview me before presenting the matter to the grand jury. 4, Detective Sharp did not obtain, request, or examine my Mercedes-Benz vehicle diagnostic data. 5, Detective Sharp did not canvass or interview any independent witnesses other than Mr. Hunt. 6, Detective Sharp did not test any part of the vehicular assault narrative against Mr. Hunt's own contemporaneous sworn affidavit that we looked at earlier, which contains no allegation whatsoever of vehicular contact. And 7, Detective Sharp confirmed the arrest date as June 25th, 2025. Here we go. This is the T, because I saw the word giglio on the docket. Giglio, 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 however you want to say it. Giglio. I'm sure there's more pronunciations than I'm exhausting here. Detective Sharp pleaded guilty before New York Police Department Tribunal to an act likely to be injurious to a child under 17, his own 3-year-old son. The single most important disclosure in Exhibit G is disclosure number 7, memorializing New York Police Department Advocate's Office, case number, and the acronym is DADS. The department, that's nice. The department charged him with 3 specifications, the second of which was verbatim, knowingly acting in a manner likely to be injurious to the physical, mental, or moral welfare of a child less than 17 years old. That child was his own 3-year-old son. The disposition on the face of Exhibit G is 1 guilty, 2 guilty, 3 guilty plea. The balance of Exhibit G. Exhibit G discloses 11 additional matters involving Detective Sharp, including a federal civil rights action. This is the case of Robertson v. Sharp. 2 substantiated 2019 failures to make required notifications to the duty captain and Internal Affairs Bureau, a substantiated 2023 finding for an incomplete or improper memo book, a 2011 allegation of excessive force, and a 2019 allegation of racial profiling. Corroboration in contemporaneous public reporting. The events underlying disclosures numbers 6 and 7 of Exhibit G were matters of public record. According to contemporaneous news reporting, Detective Sharp, then assigned to NYPD's Brooklyn's gang unit, did he get rehomed? Was arrested at his home in Belmore, Long Island, and charged with 3rd-degree assault, endangering the welfare of a child, and 4th-degree criminal mischief after he became inebriated and struck their 3-year-old son Connor in the face, causing swelling and bruising to the child's right eye, cheek, and nose. The child told responding officers, "My daddy punched me in the face." True and correct copies of the contemporaneous news reports are annexed here too as Exhibit H. Why that Giglio record is relevant here. I raise Detective Sharp's Giglio record not to disparage him personally, but because it bears directly on the credibility of the grand jury process by which Reed Smith LLP's ex parte narrative was carried into the grand jury room. On May 26, 2026, Justice Fong Frederick dismissed the indictment resulting from Detective Sharp's testimony. On June 18, 2026, a second grand jury, presented without Reed Smith's ex parte materials, declined to return an indictment on any charge. The motive. To bury, and from this, it seems like the claim is that the only difference, and I don't know if that's a true inference, a correct inference, is that the only thing different about the 2 presentments was that they don't give the grand jury Reed Smith's ex parte materials. The motive. To bury the underlying allegations against plaintiff, I state the following not for its truth in this proceeding, but to make plain to the court what, in my sworn belief, motivated the campaign described above. Plaintiff is the subject of serious sexual misconduct allegations involving minors. Those allegations are the subject of Mr. Dixon's federal court action against plaintiff, Dixon v. Cartagena, and are further reflected in plaintiff's own recorded music. So we're going into lyrics, including the track She's My Mama, in which plaintiff describes, in his own voice and his own words, sexual acts committed with a 16-year-old female, and 2, in sworn deposition testimony given by a Jane Doe witness who has attested that when she was 13 years of age, she met plaintiff at a nightclub in New York City, was led by him to the venue's VIP section, and was there coerced into performing oral sex on plaintiff. Now we're going to look at this deposition. And, I would hope that this didn't actually happen for the sake of any purported victim. I would always hope that these things don't actually happen. I also think it's important for people to come forward. But I'm going to be real transparent and tell you I have major concerns because the date of this deposition is April 14th, 2026. That's almost a year on the nose of the complaint being filed by Fat Joe. It's way after the attempt to serve the process server. And it's after the close of the discovery window. Despite what's being represented in this document, the discovery window is only open for the limited purpose of getting these depositions complete. There has been repeated representations and requests, I think orally at hearings as well in some of the written motions, by Fat Joe's team. Look, some of this litigation at the heart of what we're saying was extortion, and what's being alleged in social media posts that we're calling defamation. You've got Blackburn and Dixon representing that they have recordings, they have proof, they have statements from underage victims of purported sexual acts, sexual assault, victimization by Fat Joe. And they've asked more than once, turn that over. And they've told the court, They still haven't turned these things over, Your Honor. Discovery has been closed. And I see no indication that this request was ever satisfied or responded to. But then we get a deposition from April 14th, 2026. And I think this is why I said at the beginning of this, because not going to lie, when I was scanning, I'm like, what do we got? 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 What? So that caught my eye very quickly. And I don't know. I just think it's hugely problematic. I mean, you have Fat Joe's team requesting this more than once. They had ample opportunity. The discovery was extended at the end of last year to the beginning of this year, and this stuff still wasn't produced, even though there's been explicit requests for this material. And now you've got an issue that, I don't know. First of all, how much could this go to establish that if Reed Smith and Ian Turetsky and whoever else is alleged to have, because of the knowledge that's supposed to be supported by this April 2026 deposition, that they had knowledge of this back in May and June of last year when they purportedly coordinated to have this process server scheme to falsely claim that someone make this false accusation that Tyrone Blackburn tried to hit you with their vehicle and then report it to the media before there's even anything in NYPD systems. If your argument is going to be that that whole scheme was coordinated to silence your advocacy for victims, how would they have been aware of this? And they've been begging for you to produce it. So I think we have a major issue for Tyrone Blackburn standing his position as a defendant in the case that Fat Joe filed against him and Terrence Dixon and Tyrone Blackburn's law firm. I also wonder if Blackburn was relying on this particular Jane Doe that we're about to read this deposition from for anything that previously transpired in this litigation, any of the pre-litigation conversations, if this is one of the Jane Does, because the accusation was that there were like multiple victims or whatever. Why haven't you already produced this stuff? Why haven't you already produced this witness or testimony from this witness in discovery in these underlying cases? And lastly, as a concern for Terrence Dixon, who I have concerns about the good faith basis behind Terrence Dixon's claims to the court. I mean, he's supposed to, even though he's not the attorney, he's still supposed to not be making stuff up to bring a counterclaim against somebody, a companion case against somebody. What type of advocacy did you do for your client? Now you're trying to withdraw, and we're finding out about this new deposition in the course of you trying to withdraw your representation from Terrence Dixon. But we don't get any of this. We don't get any of this until after or when you're trying to withdraw. You don't file this as part of the discovery response in your representation of Terrence Dixon. If this witness is credible, if this witness, what they're saying is true, this would be a major defense to the defamation claims against your client, Terrence Dixon. Why wouldn't you have filed this? So I don't know. But let's see what it says. It's 12 pages here, but it cuts off at the end, I think. So I don't know if it was only 12 pages or what, or how much longer it could have been. They read Rule 29 stipulation into the record. So the attorneys appearing in this deposition acknowledge that I'm not physically present in the deposition room. Oh, and I think it was just Blackburn present. But let's double check. All right. April 14th, the deposition was what? 25 minutes? 25 pages total. This whole document is 12 pages. It says, on behalf of the defendants, Tyrone Blackburn and T.A. Blackburn Law, but we don't have Terrence Dixon listed here. No exhibits were marked, so no exhibits were admitted during this testimony. All right, so Rule 29, the attorneys appearing in this deposition acknowledge that I'm not physically present in the deposition room, that I will be reporting on this deposition remotely, and that I will administer the oath to the witnesses remotely. The parties and their counsel further agree that while I'm a licensed notary, the witness may be in a state where I am not licensed. The parties stipulate that this deposition may be taken before me. If any party does have an objection to this manner of reporting or anything stated above, please state your objection now. And so it's weird, was Fat Joe's team even notified that this deposition was going to take place? I can't imagine that one of his million attorneys wouldn't be there if they were aware. And I assume it's this underlying case, because why else would it be on behalf of defendants Blackburn and the Blackburn law firm? So the court is hearing no objections. We can proceed. So we've got the Jane Doe is called as a witness, having been first duly sworn to tell the truth, the whole truth, and nothing but the truth, and was examined as follows. By Mr. Blackburn. All right, so just for the record, I just want to confirm that Miss Jane Doe ID'd herself through her New York State driver's license ID. She, by placing it up to the camera, and I believe Madam Court Reporter ID'd that and witnessed it and can confirm that she did present her identification. So, but that's just the beginning. So, all right. Please state your name for the record and spell your last name, and then they go through the name. They redact her date of birth. Where do you currently live? Baldwin, New York. And what's the highest level of education that you've completed? Bachelor. Okay. For what area? Psychology and sociology. Okay. Have you ever given testimony under oath before today? No. Well, so we know this isn't just a follow-up. This isn't somebody that we had give sworn testimony during the discovery period at all. So did we do our due diligence? if this is someone that we're relying on for everything that occurred in 2025 or as a defense against the defamation claims. It says, okay, and you've never sat in a deposition before, correct? No. Okay. Do you understand that you're under oath today and must answer truthfully to the best of your ability? Yes. Okay. If at any time you do not understand the question, will you let me know so I can rephrase it? Yes. Okay. Okay, so we're going to go back to the early 1990s. Do you know of an individual by the name of Joseph Cartagena? He's a rapper. He goes by Fat Joe. I did as a teenager, yes. Okay, and have you ever met Fat Joe? Yes. Okay, when was the first time you met him? It was early 1994. It was probably around like spring, like late March, early April. It was in Manhattan at a club called Velvet. Okay, and what were you doing at Club Velvet at the time? I was there with my cousin and just being young and having fun. And okay. And you said being young, how old were you at the time? 13. You were 13? Yeah. Okay. And you said you were with your cousin. Which cousin was this? It's my cousin, and that's redacted. She's a dentist now, but she was with me at the time. Okay. And at the time, to the best of your recollection, how old was redacted? Redacted is, let's see, if I was 13, she'd probably just turn 16. Okay, because yeah. And at the age of 13, were you in junior high school? High school? I was in the 8th grade. And when you were at Club Velvet, I assume that you met Mr. Cartagena. What was he doing at the club at that time? I really just sitting down, like I really didn't even really notice him until he approached me, so I don't know. Okay, so he wasn't performing or anything? No, no, no. Okay, and when you said he approached you, to the best of your recollection, could you recall, like what his appearance was? Was he heavy? Was he slim? Yeah, no, he was heavy. He was heavy. He wasn't he was heavy, yeah. Was he bald at that time as well? Yeah, yeah, I would think so. I can't recall. Yeah, I would think so. Okay, and did he, to the best of your knowledge, could you describe what he was wearing? Was he wearing like a jean outfit, a tracksuit, velvet suit? Was he wearing a hat? I would ask that. I have no idea what he was wearing. I only remember what I was wearing. I mean, fair enough. Okay, what were you wearing? I was wearing like a white sweatshirt and a red bubble vest. It wasn't something that I would normally wear. It was like more of a I don't know, like a I tend to dress up, but I didn't. I didn't even dress up that night. Okay, and your cousin, was she wearing something similar? Did she dress up or not really? No, she never dresses up. Like, no. Yeah. Okay. Especially back then. Back then we had baggy clothes and, it was a different trend than now. Okay. And you said that he approached you. When he approached you, what did he say to you, if you can recall? I'm pretty sure that it was probably no more than like, come here, or, maybe a gesture, or I don't know. He had a separate area in the back there. Uh, and there were a lot of, and question says, okay, so was it like a VIP area? I wouldn't say so, because there was no one else in there. And I feel like normally in a VIP area, there's other people. So it seemed more of like a private area than like a VIP area. Okay, if that makes sense. Okay, was he drinking or smoking back there? I have never seen him smoke, and to my knowledge, he doesn't drink. I've never seen him drink or smoke, which is, yeah. Okay, okay. So when he approached you, what happened after that? I don't know. I was young and stupid, and he started, I guess, complimenting me. And I don't know, somehow, I hate to say it because it's when he, pushed me or suggested me to give him oral sex, I did. Okay, so you said that he requested you to perform oral sex on him at that time? Yeah. Okay. And did you do it at the club while? Yes. Okay. And what part of the club? At the private area. In the back where he was sitting? Yeah, yeah. I can visualize the club. And there's a lot of curtains but he was just, because I remember there was a female that came and she was, asking, who is this? And he said, oh, that's just and then that's where the exhibit ends. That's where the exhibit ends. So this is the deposition from someone who, according to this deposition testimony, was never given a statement under oath before. And maybe that's going to be the excuse of why we didn't put it forth in discovery. But I think it's going to create a real tricky situation to be relying on it now as part of a motion to withdraw. But let's see. Let's see. They say it is my sworn belief, based on the totality of the conduct described in this declaration from the Jane Doe, that Reed Smith, Mr. Turetsky, Mr. Tacopina, Mr. Hunt, the Hunt Group LLC, engaged in the campaign described above for the purpose of stigmatizing me, terminating my representation of Mr. Dixon, and bearing the underlying allegations against plaintiff before they could be adjudicated on their merits. The disciplinary complaint and the prior notice to the court. In addition to the criminal collusion described above, counsel for plaintiff and their agents also lodged a disciplinary complaint against me with the Attorney Grievance Committee for the New York State Supreme Court Appellate Division. I raised the pattern reflected above and the litigation by ambush character of plaintiff's counsel's conduct before this court previously, and no relief was granted. I mentioned that history not to relitigate it, but be candid with the court about why I'm seeking withdrawal now at this stage. I wonder if this is in reference to Judge Williams saying that there was no merit or whatever behind the claim of the quote unquote media collusion between Fat Joe's team and myself and or Complex magazine. Is that what they're referring to? And I believe, more specifically, the complaint against the grievance committee, plaintiff and their agents. I could be mixing issues. But I think there was an issue where, and I think it was from Joe Tacopina and his law firm's letterhead on their email. They like sent an email notifying that I think I see, or they submitted an email another law firm sent to Blackburn saying, hey, I notice that you're practicing in a certain jurisdiction when you aren't licensed to practice before that jurisdiction. And maybe I'm getting the signals crossed because there are several references to disciplinary complaints. But I do believe one of the complaints that was raised by Fat Joe's team was just like asking the court to take judicial notice of another matter in another jurisdiction where an attorney was going to file, I believe it was New Jersey, with their grievance committee for Blackburn practicing somewhere without, having proper licensure. I don't remember. there's there's so many cases. So many cases. So that one I'm not sure on what we're saying specifically here. But he's referring to a pattern. So it could be several things. And this court previously granted no relief on any of those issues when Blackburn raised them. I mentioned that history not to relitigate it, but to be candid with the court about why I'm seeking withdrawal now at this stage. So he's going to say, like, look, they keep coming for me. This is irreconcilable. There's too much hostility. Then they've got ex parte communications with the assigned assistant district attorney on the eve of my grand jury appearance. On the evening of October 14th, 2025, the night before my confidential appearance before the Kings County grand jury, Mr. Hunt transmitted to Assistant District Attorney Salvatore Prince. Oh, this was discussed at the January 9th hearing. And I thought it was weird. And the judge raised the question of, like, well, who specifically was doing it? And when there was further clarification, it was narrowed down that this is Mr. Hunt, the process server, who's the complaining witness in the then active criminal case, and not any of the lawyers. And the judge raised issues like, well, I don't really think there's the standing in this case before this court for you to bring this issue here. Like, Mr. Hunt is not a party in this case, and this case is not about the Kings County grand jury proceedings. And I remember that they worked out, like, I think it was Ian Turetsky that was present for that hearing on behalf of Fat Joe. He was like, look, I'd be happy, because Tyrone Blackburn was like, I can't even serve and request information from Mr. Hunt. I don't know their information, whatever. I think Turetsky was like, look, I'd be happy. I don't want to give contact information for Mr. Hunt because I believe there's a temporary protection order in place right now. But I can provide Mr. Blackburn with the contact information for Mr. Hunt's counsel, for his representative. And I remember that all being worked out. And that was the same hearing where Blackburn was screaming that this was not a game. I remember the January 9th hearing pretty well. And if I'm not mistaken, I do think that the transcript for that was ultimately uploaded on Court Listener if you guys want to go explore that. And I did a update recap on Twitter about what I heard when I listened in. Man, this case is a lot. So anyway, again, I thought this whole time we were going to have some ex parte communication. Like, we just have, like, this line of contact and, like, Joe Tacopina is feeding information to prosecutors somewhere. Maybe that's not the case. So on the evening of October 14th, 2025, the night before my confidential appearance before the Kings County grand jury, Mr. Hunt transmitted to Assistant District Attorney Salvatore Prince an email bearing the subject line, forward. All right, so there we go. This is where we're getting to. Forward. Blackburn Grand Jury, forwarding a message from Mr. Turetsky and attaching documents assembled by Reed Smith, LLP. Mr. Turetsky's forwarded message directed Mr. Hunt's attention to attached documents that purported to, quote, demonstrate facts adverse to me for use in the prosecutor's grand jury presentation. So then they cite an email exhibit K, which we're going to look at as part of the lawsuit stream. Those materials were furnished voluntarily, without any grand jury subpoena, court order, or other compulsory process, and without notice to me or my counsel. Mr. Turetsky was not subpoenaed by the Kings County District Attorney's Office, was not served with any grand jury subpoena, and had no legitimate role as a witness, complainant's counsel, or advisor to the prosecution. Well, by this set of facts, I wouldn't argue that this is Mr. Turetsky trying to advise the prosecution or having a direct communication with the prosecution. So you see now, even the way that Tyrone Blackburn's laying this out, to me, it doesn't comport with the Turetsky's in cahoots with the prosecution. And again, for me, the issue would be, did the prosecution disclose this information to the defendant in the relevant case, here being Tyrone Blackburn? But the duty to disclose here would fall on the shoulders of the prosecution, and I do not think this establishes a direct line between Turetsky and Prince. According to Blackburn's own recitation of the facts here. So he says he is himself acknowledged on a recorded Zoom call that he did not represent Mr. Hunt and that Reed Smith LLP was not Mr. Hunt's counsel of record. I think this is the January 9th hearing. An admission that eliminates any colorable professional justification for his intervention in the criminal matter and confirms that his transmission of documents and directives to Mr. Hunt for onward delivery to ADA Prince lacked any lawful professional predicate. All right, what is this email? Because maybe I want to look at it now and not do it as part of the law firm stream. Because this makes it sound like you have someone moonlighting as someone's attorney. Okay. So all right, so there are 3 attachments. And even though the documents aren't attached, it looks like there's summary. So we'll have to rely on the summaries. And Jamie with a different spelling. All right, so this is the message. This part here is Jim Hunt to the ADA. So this is Jim Hunt writing to the ADA. Sal, please read, please below. I'm available to speak on the morning. And then this is inset as if this is the forwarded message. So it looks like this text we can assume is prepared by Ian Turetsky, but this is not, I mean, it just says forward. But anyway, I think we can infer that this is not directly message. This is what's quoted and then forwarded, and then this is the only direct message writing prepared before this email was sent to the prosecutor. So the inset text reads, Jamie, see the attached and below which you can share with the ADA. Thanks, Ian. And then it says, we gathered the attached documents which demonstrate that Blackburn knew he was going to be served. Okay. Tab 1. Joe sent Blackburn a cease and desist letter on April 29th, 2025. Moments later, Blackburn wrote that he would gladly waive services for any BS lawsuit your pedophile client wants to file against me, and I'll gladly meet you at the Southern District of New York Prosecutor's Office to file your extortion claim. Let me know what time you want to meet. Tab 2. Joe sent Blackburn his complaint on April 29th, 2025. Blackburn and Joe have a back and forth over the next few days, but do not discuss waiving service. Rather, on May 1st, 2025, Blackburn states, I plan to fly in from Florida for the start of the Diddy trial, but I'm willing to come today if you want to meet with the Southern District of New York and Homeland Security tomorrow. Well, again, like I said earlier, because we pulled up that Instagram, I think there's a problem if you want to argue that some secret information is somehow going through a direct line, quote unquote, from Fat Joe's team to the prosecutor in a criminal matter, when this is publicly pinned to your Instagram profile right now, still. Tab 3. on May 8th, 2025, Blackburn A left no doubt that we were trying to serve him, that he knew, maybe they were missing a word. Probably supposed to say that he knew we were trying to serve him and his client. B, conditioned waiving service on meeting at Homeland Security, which we never agreed to. And C, lies about he and Blackburn not being domiciled in New York. My client informed me that he received a call from his grandmother informing him she'd been served with your summons and complaint. I checked the docket and your process service affidavit confirms the same. Unfortunately for you, my client does not live with his grandmother. In fact, my client does not live in New York State at all. Now it is your duty and obligation to locate his correct domicile. So this is information being sent by Blackburn to Fat Joe's team that Fat Joe's team is including in this response. And this all seems very relevant to if one of the defenses that Blackburn was going to raise and argue was they never should have been trying to serve me in the first place. So I wouldn't have expected that the person, if I'm backing out of my car I thought that they were just someone heckling me after the Diddy case because they didn't like what was going on in the Diddy case. I couldn't have considered, I wouldn't have thought to consider, it was just somebody trying to serve me papers. This is all relevant information. And I don't think it helps Blackburn. But this is interesting to see. Next it says, I offered to waive service of process weeks ago in exchange for you and your client meeting with me, Homeland Security, and the AUSAs for the Southern District of New York, so you can present your case for extortion, and I can present my case for murder for hire, as well as sex trafficking of several minors. You've yet to respond to my invitation. And as an aside, I also noticed that your subpoena indicates my domicile is 1242 East 80th Street in Brooklyn, New York. That is entirely inaccurate. Didn't you testify that in front of the grand jury? So I know these are old communications, but what do you think the difference is? If these communications are supposed to be from May 8th, 2025, and then between May 12th and whenever the affidavit was filed on May 20th, the attempted service happens in the driveway of 1242, which we get this testimony later that at that time, that's where my law office and my residence was. Do you think this is helpful for Tyrone Blackburn to include as an attached exhibit when he's also trying to rely on the previous judge's order saying, look, even though the judge in the previous cases that the prosecutor tried to cite during this grand jury testimony, they did conclude that they didn't find him entirely credible, the way some of the questions were asked was improper. Then we get this blatant misrepresentation. Oh my God. Oh my God. Though, is that entirely inaccurate? Blackburn says it's entirely inaccurate. I'm not inclined to agree. Blackburn says that as with my client, I am also not domiciled in New York, seeing as though you lack federal question jurisdiction and have woefully failed to substantiate diversity jurisdiction. Your case is incorrectly filed in the Southern District of New York. I advise you to notify the court of your error, withdraw the case, do your research, and refile in the appropriate jurisdiction. Mr. Tacopina should know better than to improperly file cases in federal court to garner media attention, embarrass defendants with salacious allegations, and pressure defendants to settle. And then that's the end of the what's forwarded here, or at least included in this exhibit of what was forwarded here. So this is interesting. So he's already hopping on Tacopina, quoting a court's ruling relating to himself, arguing that, oh, you should file in the appropriate jurisdiction. And again, it's been over a year now, and the case still exists. The case lives on. The case lives on. So, oh man. I, whatever. We're squeezing the orange juice on this one. I don't think that that's helpful. It just seems like, again, hoping that you can make whatever argument you want to argue here and that people won't go look at the exhibits. And I'm glad we did. I'm glad I didn't save that for the lawsuit one because it's relevant to the claim here of ex parte communications and some direct line of access. So anyway, he says that, let's see, that Mr. Turetsky's forwarded message directed Mr. Hunt's attention to attached documents that purported to demonstrate facts adverse to me for use in the prosecutor's grand jury presentation. Those materials were furnished voluntarily, without any grand jury subpoena, court order, or other compulsory process, and without notice to me or my counsel. Mr. Turetsky was not subpoenaed by the Kings County District Attorney's Office, was not served with any grand jury subpoena, and had no legitimate role as a witness, complainant's counsel, or advisor to the prosecution. I honestly don't see that email as being any of these three things. Again, it goes back to my issue of if the prosecutor is receiving this information, it could be a discovery violation if the prosecution doesn't let the defense know, like, we have this information. So, and is is it really ex parte in the problematic sense? Like, I get that he's not included as a party, and like ex parte could just mean without the presence of a party, but is he trying to apply it's like ex parte the same way everybody freaked out when Glanville tried to hold Brian Steele in contempt for trying to raise an issue with an ex parte that involved the court's presence and nobody told the defense about it? Like, is he trying to use the phrase ex parte to drum up some, like, ooh, something scandalous is going on? When really, ex parte meaning something between a complaining witness and the prosecution, that's not the same way that what I would say ex parte became famously associated with a judge and a prosecution team meeting with a key witness, and none of the defendants were put on notice about it, even after the fact. It's not comparable. It's not comparable. But I think we're using that inflammatory phrase because of how much fanfare people gave Brian Steele and how much condemnation people gave Judge Glanville and the prosecution team for that ex parte. I think we're using a familiar phrase with two not comparable situations. But okay. So, all right, they've got, let's see. They're not, yeah, I think this comes from the January 9th hearing, because I think that was Teams, not Zoom, but I think people use Zoom the same way they use the phrase Band-Aid. That Turetsky acknowledged on a recorded Zoom call that he did not represent Mr. Hunt and that Reed Smith was not Mr. Hunt's counsel of record, an admission that eliminates any colorable professional justification for his intervention in the criminal matter, and confirms that his transmission of documents and directives to Mr. Hunt for onward delivery to ADA Prince lacked any lawful professional predicate. All right, maybe new civil actions commenced by undersigned counsel. And I think this is the meat and potatoes here. We file these 3 lawsuits, and now we're relying on these 3 lawsuits where I am a plaintiff to say, look, I need to get up out of representation of Dixon in these other matters. So following the termination of the criminal matter, and based on the record developed therein, I have commenced 3 separate civil actions in the Supreme Court of the State of New York, County of Kings, arising out of the same operative facts. On June 24th, 2026, I filed a verified complaint captioned Tyrone Blackburn. This is against Tacopina's law firm, asserting claims sounding in defamation per se, defamation, tortious interference with an existing client relationship, negligence per se, trespass to land, negligent hiring, retention and supervision, and violation of New York City Administrative Code 20-409.2. Also, this is all June. Oh, 2 days later, I filed a verified complaint captioned Tyrone Blackburn v. TMZ, Fox Television, Fox Corporation, Harvey Levin, Charles Latiboudiere, and ABC Corporations 1 through 10. Asserting claims surrounding in defamation per se, defamation in the alternative, and tortious interference with prospective economic advantage. On June 30th, I filed a complaint captioned Tyrone Blackburn versus Reed Smith, Ian Turetsky, the Hunt Group, James Hunt, Nicholas Palmieri, John Doe's 1 through 10, and XYZ entities 1 through 10. Asserting claims against Reed Smith and Ian Turetsky, plaintiff's co-counsel of record in this action, together with claims against the Hunt Group, James Hunt, Nick Palmieri, and that's annexed as an exhibit. So again, we're going to do those on a separate lawsuit because that's going to be really long. As of the date of this declaration, I am accordingly a plaintiff litigant against 1. Plaintiff's own counsel of record in this action, namely Joseph Tacopina and his law firm, and Reed Smith and Ian Turetsky. And 2. Witnesses and other individuals, including James Hunt and Nicholas Palmieri, whose conduct, credibility, and documentary record are or will be central to the defense of Mr. Dixon in this action. I'd love to see this argument play out. But okay. Because again, process server happens after this issue. All right. Okay. The non-waivable conflict of interest. And okay, so this is just going to go through the legal. the stuff that we read in the memorandum of law, the legal stuff. The conflict presented here is direct and personal. I'm now an adverse litigant in 3 pending state court actions against plaintiff's counsel of record and against witnesses whose conduct is intertwined with the defense of Mr. Dixon in this case. A reasonable lawyer would conclude, and I have concluded, that there is significant risk that my professional judgment on behalf of Mr. Dixon's action would be adversely affected by that adversity. The risk is not theoretical. It is present in every interaction with opposing counsel, in every discovery and motion decision, and in every strategic choice. Yeah, I mean, I think the argument in and of itself is enough to support this motion. I think some of the other stuff we're sprinkling in might just be to get stuff on the public record and give the public access to things like this April 2026 deposition. They go through the law again, the irretrievable hostility. I want to see if this is worded different, though. So he raised this ground, and here in the affidavit, he says, I'm compelled to be candid with the court. The events described herein, the arrival of unlicensed agents at my home and law office, the fabrication of a vehicular assault narrative against me, the ex parte transmission of materials to the Kings County District Attorney on the eve of my confidential grand jury appearance in an effort to tank my grand jury appearance, my arrest and prolonged criminal prosecution. Are you arguing that something that happened outside your presence was meant to deter you from testifying, making an appearance? That doesn't make sense. The ex parte transmission, I was not a party to this transmission, was an effort to tank my appearance. My arrest and prolonged criminal prosecution before 2 grand juries and the subsequent denials of responsibility by plaintiff's co-counsel have generated, so they've apparently denied this, have generated on my part a depth of animosity towards plaintiff's counsel of record that I'm unable to conceal from myself, and that I will not misrepresent to this court. That animosity is not a passing frustration. It is the settled and, in my honest self-assessment, irreconcilable product of what I believe was done to me and to my family. The criminal matter is over. The animosity it produced is not. On the morning of June 25th, 2025, a warrant squad arrived at my home. So why didn't you raise this issue before July of 2026? Why did you continue to represent Dixon for a year without moving to withdraw? In fact, you fought to stay on the case when Fat Joe's team brought up that you represented to 4 other cases in Jersey, that because of things that you were going through, you were unable to proceed with your legal work in those matters. And you insisted to Judge Rochon that that was not impacting your ability to do your legal representation for yourself and for your client as a co-defendant in these matters. Why did we wait a year if we're relying on that now? On the morning of June 25th, 2025, a warrant squad arrived at my home at 5 a.m. I watched my mother's face when she heard the knock at the door. I watched the tears run down her face. That image, my mother in her own home, reduced to tears at 5 in the morning because of a warrant that should have never been sought and a charge that a criminal court justice and second grand jury ultimately refused to sustain, is burned into me permanently. To dispatch 2 individuals with the documented records described above to ambush me in my own driveway, and then to manufacture a felony charge out of that encounter to protect an individual whose own recorded words identify him as a predator of minors, is not zealous advocacy. It is malicious bad faith litigation. The depth of feeling I carry about what was done to me and to my family is visceral. I state the following plainly and under penalty of perjury. And again, I think you have a problem raising this argument when saying that this happened on June 25th, 2025, but you continued to represent Dixon, even when opposing counsel was pointing out. Don't you think that's a conflict? Can he really raise proper defenses against the defamation claims that Fat Joe's raising against you and your client, Terrence Dixon, for claiming that he's a pedophile? He's trying to say that that's defamation. Can he really defend himself if you're his attorney and you keep silencing him and we're asking questions about his basis for making those claims on social media and in other places and other statements to the public? Why is this an issue now and not earlier? So I state the following plainly and under penalty of perjury. A, I regard any physical proximity to plaintiff's counsel of record and their retained agents as unsafe. I say that not for effect, but because it's true. They failed in their effort to have me convicted, and I do not trust that they would not orchestrate another retaliatory action against me. Given the intensity of my personal reaction to what has been done to me, and given the pending state court litigation in which plaintiff's counsel and their agents are adverse defendants to me, I do not believe that requiring me to appear in the same physical space as plaintiff's counsel and their retained agents, whether at deposition, at conference, or at trial, is consistent with the safety of any person in that room, including my own. Withdrawal is a responsible course. Even if the court were to conclude that Rule 1.7 conflict alone did not compel withdrawal, which respectfully, I do not believe it could, the personal hostility and safety considerations set forth above independently constitute good cause for withdrawal under Local Civil Rule 1.4 and Rule 1.16C7. I have never before in any matter sought withdrawal on these grounds. I do so here only because the circumstances of this case and the conduct of plaintiff's counsel and their agents towards me and my family leave me no alternative consistent with my duties to Mr. Dixon and to this court. I raised these concerns before this court on more than one occasion during the past year. I complained of litigation by ambush. I moved for reconsideration of the motion to dismiss, which I continued to believe was erroneously denied. My complaints were not meaningfully addressed. Your motion for reconsideration of a motion to dismiss has nothing to do with your claims that something that happened when you were arrested. What? That's not raising this particular issue. But okay, like we're just throwing that in here. My complaints were not meaningfully addressed. All right, we're attacking the court. If I had done to plaintiff's counsel what plaintiff's counsel and their agents did to me, coordinated a pre-dawn ambush of a colleague at his home, transmit ex parte materials to a prosecutor on the eve of that colleague's grand jury appearance, and then stood before the press and declared that he had mowed down a process server. All right, well, Judge Frederick Fung, in his findings, said that his view of the evidence showed that the process server moved back with your vehicle and that his knee was subsequently bloody. So, I mean, we can dispute the idea that maybe he didn't stumble and fall, and maybe a figure of speech is crossing the line to say mowed down when I think that's colloquially used as a phrase, someone hitting somebody with something moving. If we're going to pick hairs, okay, maybe. But I don't think this representation that a judge found that it was a lie, that you hit a process server. That's not to me what the order from the judge said at all. In fact, he found that the injury seemed to be subsequent to the moving of your vehicle. This court would have been incensed, and the consequences to me would have been swift and severe. I also disagree with that because Judge Rashawn over and over and over and over and over declined to issue any punitive sanctions to Blackburn and emphasized, I've already told you before. And then the next time, I already told you before again. So I don't think that this is based on the record of the history of this case, that this is true, because Blackburn's been given a ton of grace from this court. So I disagree that consequences, when issues have been raised with Blackburn, have shown to be swift and severe. There haven't been consequences at all until very recently, where he was ordered by Judge Rashawn to merely pay the cost of the videographer. No punitive sanctions, just cost of Veritext for the missed February 6th and 9th court-ordered depositions that he didn't show up for. So we've had the opportunity to see what consequences the court over and over would place on Tyrone Blackburn, and I would not characterize them as swift or severe. And in most instances, in all but one, the consequences have been non-existent, except for I'm warning both parties, follow the rules of the court, and nothing more. So, that asymmetry is part of the record I'm placing before the court. I don't think it's part of the record. What are you imagining? not as a basis for relief in this motion, but because candor requires me to explain fully and honestly why continued representation of Mr. Dixon under these circumstances is not something I'm able in good conscience to do. Rule 1.16b1 requires withdrawal where continued representation would result in a violation of the rules of professional conduct. Rule 1.16c7 permits withdrawal for good cause. In my professional judgment, both are satisfied here, quite apart from Rule 1.7 conflict already established. And then satisfaction of Local Civil Rule 1.4. 1.4 permits withdrawal only upon a showing by affidavit or otherwise of satisfactory reasons for withdrawal and upon consideration of the posture of the case, including its position, if any, on the calendar, and whether or not the attorney is asserting a retaining and or charging lien. Satisfactory reasons. The emergence of pending active hostile litigation between undersigned counsel and plaintiff's counsel of record, the concurrent adverse posture towards witnesses central to Mr. Dixon's defense, the resulting non-waivable conflict under Rule 1.7, the mandatory withdrawal obligation under Rule 1.16b1, and the personal safety considerations arising from the underlying events are, respectfully, more than sufficient to constitute satisfactory reasons under Rule 1.4. Posture of the case. The case is not on the trial calendar. The Rule 11 motion has been decided. There's no imminent event which the court is required to adjourn to permit orderly transition to substitute counsel or to pro se status. And then no retaining or charging lien. So undersigned counsel, Blackburn, is not asserting a retaining lien or a charging lien against Mr. Dixon's file or any potential recovery in this action. Mr. Dixon's complete file will be delivered to him promptly, and undersigned counsel will cooperate reasonably with any successor counsel in the orderly transit of the representation. And then arguments that there's no prejudice. So, I mean, we read this in the memorandum of law. He says, I've advised and will continue to advise Mr. Dixon of the facts and circumstances giving rise to this motion and of his rights and options upon withdrawal to the extent consistent with the constraints described in the preceding sections. And then reservation of rights. Undersigned counsel expressly reserves all rights, remedies, and claims arising from the conduct described in this declaration and in the actions referenced herein, including without limitation, rights and remedies under Federal Rule of Civil Procedure 11, 28 U.S.C. Section 1927, and the court's inherent authority. This motion seeks only leave to withdraw as counsel for defendant Terrence Dixon and a limited 60-day stay of proceedings and does not request substantive relief against plaintiff's counsel or any other party at this time. Nothing in this declaration shall be construed as a waiver or forfeiture of any such rights or remedies, all of which are expressly preserved. No prior application for the relief requested in the accompanying motion has been made. And for the foregoing reasons, I respectfully request the court enter an order granting leave to withdraw as counsel for defendant Dixon, stay all proceedings for 60 days, and grant such further relief as the court deems just and proper. Declare under penalty of perjury that the foregoing is true and correct. July 8th, 2026, in Brooklyn, New York. We're not domiciled here. So, respectfully submitted, Tyrone Blackburn, T.A. Blackburn Law, PLLC. Oh, man. So that was a time. That was a time. Yeah, we've been at this for 3 hours, and it's like we still got to do. We got to do a stream on the Rock Nation motion for sanctions in Dixon v. Cartagena versus and everybody else, and Rock Nation's very quick response, like, "Hey, there seems to be several citations, hallucinated citations, in this filing from Tyrone Blackburn. So we'll see how that goes. We'll take a look at both of those." And then we've got to do a stream on the Musketeer lawsuits, the 3 lawsuits. So I think we have a good, like, overview about those lawsuits just based on what we saw represented about them in the filings we looked at today. But yeah. Oh, wait, we've got new stuff. I wonder if this is a motion to expedite sealing of a deposition transcript. Hold on, let me see if I can pull that up. I feel like it's got to be about that Jane Doe deposition transcript. All right. Yep. And I wondered if we were going to see a violation of the court's order on this. Tacopina is moving. Tacopina is moving. Not quick enough, and he surely did not provide me with this filing because he doesn't even want it out there. So let's see. Do we have a timestamp on this? No. A lot of these ECF filings, you'll get the date, but you don't get the time that it's filed. So the best way I can tell is, like, if I get alerts from Court Listener, I get the timing that Pacer pushes out the notification for it. But other than that, it's not like other courts where sometimes we can see this was filed at 4:27 p.m. or something like that. But they say here, Your Honor, I'm counsel for Joe Cartagena in the above referenced actions and right pursuant to Your Honor's individual practices to seek leave nunc pro tunc to file Mr. Cartagena's letter motion, which is being contemporaneously filed under seal. As set forth in the letter's motion, Mr. Cartagena's, and that letter's not available, I just tried to open it, which is being contemporaneously filed under seal. As set forth in the letter's motion, Mr. Cartagena seeks to strike from the public docket material that violates the court's December 8th, 2025 stipulated confidentiality agreement and protective order. Given the emergency nature of the relief sought and the need to prevent further dissemination of material protected by the protective order, plaintiff respectfully requests leave nunc pro tunc to maintain the letter motion under seal. Sealing is appropriate because the letter motion necessarily discusses highly confidential, attorney's eyes-only material protected by the protective order and seeks relief directed at preventing further dissemination of that material. So my guess, and it could relate, let's see, docket number 1. Do we have anything else? Right? Yeah, because this is under seal. And we'll see what gets pulled. We could find out if it only, I'm assuming it's got to apply to this. But maybe the request pertains to other exhibits as well. And this is the thing, like, on the way out, the court's got to grant his request to withdraw because it would be wild to let him continue. There's no way he could continue. But I hope in whatever order granting it, we do get mentions of, hey, once again, on the way out, you still fail to follow the court's rules. You also, we think you made some misrepresentations here. I mean, the order, even though it's ultimately going to be granted, the order they could pull a Frederick Fong and put some spice in their order. Derek, good to see you, Derek. Derek says this case is crazy, doesn't make sense. Were you present when we read the deposition transcripts? I feel like the deposition transcripts like really illustrate why we have such crazy happenings on the docket. Some of the most wild deposition testimony I've seen. And again, the what makes it extraordinary is that it's coming from an attorney. The behavior is coming from an attorney who's also a party to the case. So it's some wild stuff, wild stuff. Outsider says, what are the rules for a process server in New York? Can anyone serve a case? So that's a good point. Because is there a requirement that somebody needs to be a private investigator? Because the issue, and I only see you popping in somewhat recently. So the issue, from my understanding of the way that Blackburn framed it, is James Hunt is a private investigator, but he wasn't licensed as a private investigator at the time he served these papers. I mean, is that a requirement, or is the issue just that he represented in his affidavit relating to service that he's also a licensed private investigator? So should the issue just be constrained to the representation in that affidavit? I don't actually know. And again, I still think there's an issue because it seems like Blackburn's explicit call out was the licensure for, maybe we can just look at the exhibit. I didn't think it would be that interesting. Yeah, it's not okay. That one's not available. Um, yeah, so maybe that's why I didn't grab that one because it's not there. Maybe they're all not available now. Nope, that one would let me go into it. So for whatever reason, the licensure one's not available. Maybe it contains like personal address information or something. I don't know. Maybe this is one of the things that they want to have under seal. Uh, or this one. I don't know. Maybe it quickly got pulled down since the filing of that request to seal and strike from the record. I don't know. But usually we would see this button go away, and I still see it when I refresh that there's an option to purchase it. And it's not unusual for Pacer to say that something's unavailable. But yeah, other sanctions incoming. I mean, I would imagine, Derek, it really is wild. This whole case, is a hot mess, and um, again, this originated as Fat Joe filed the first lawsuit, but I believe it made bigger news when I think in June. I always forget if it was June or July, but I think it was the end of June, like June 29th or something, 2025. Terrence Dixon files his own lawsuit against Fat Joe, Rock Nation, a bunch of different parties, Pistol Pete, alleging civil RICO and this huge cover up scandal. And it was like raising these issues where so and so, these parties either knowingly allowed, participated in, or helped cover up or facilitate like sex acts, sex abuse, sex trafficking, human trafficking. But the allegations didn't all relate to Terrence Dixon. So it's like he was bringing this lawsuit on behalf of other victims, which the posture of it was just weird. But that went viral. That went viral, and a lot of people, when they were reacting to the news of that filing, had no awareness that there was this lawsuit already in play filed by Fat Joe for defamation relating to these claims by Terrence Dixon and in cahoots with his attorney, Tyrone Blackburn, to make these public statements that Fat Joe is a pedophile. Public statements on Instagram posts that Fat Joe is a pedophile. So Fat Joe's been fighting against these claims, pushing back these complaints, these claims long before Terrence Dixon filed this claim about a civil suit with all these other victims when he's the only party suing. It's just a lot. And now he's amended Terrence Dixon after missing certain deadlines to respond to, because there's multiple parties in the companion case, all these different like motions to dismiss from the different parties, or like everybody but Rock Nation, they'll group up and they'll do like an omnibus motion to dismiss, but then file their own supplements that dive into issues that only pertain to themselves and don't need to be part of that omnibus motion that all parties join in on. Terrence Dixon missed the deadline to file a response to those motions to dismiss. So then late, Tyrone Blackburn files this motion requesting to amend the complaint, which kind of moots all the old motions to dismiss. Court grants narrow permission to do that. And then the civil RICO claims are removed from the second amended complaint. Like, it's just this whole, it's just like such a whole hot mess. Oh my goodness. And for me, from the position I'm standing in, again, I'm coming from a place where Tyrone Blackburn made an odd and untrue conclusion about me, thinking that the stuff I do on this channel is based. I don't go out and sleuth for like special insight information from attorneys. It's just I like to look at the docket, and sometimes the docket takes you on a deep dive. Sometimes there's emails included from attorneys. Sometimes you get that stuff through the docket. But I do like to constrain myself to stuff mentioned on the docket. I don't go out, I don't seek tips from anybody. I'll seek recommendations, what's an interesting case to look at. But I've never sought out, hey, can you give me insider information? And I don't think anyone's really reached out. Not that I've seen. I don't think anyone's ever reached out to me like, hi, I'm an attorney for this person. Can you publicize this for me? I don't think I've ever been on the receiving end of that. But if I had that opportunity, I think it's distasteful. I think it's not the way I'm interested in following a case. I like things to be from the docket, and I like to advocate for transparency and access to what's filed in a court case so we can see for ourselves. Um, and I think that access should come through the docket, come through the official records. So when Tyrone Blackburn wrote in this filing that a YouTuber, you know, that Fat Joe's attorneys colluded with me, the YouTuber, I just thought it was so dumb. I thought it was just so unfounded. I thought it was meritless. I was very happy to see that Judge Willis agreed that the claims were meritless. It was really against me. I'm the YouTuber, and then Complex Magazine. Like, it's I have a lens now because of how you accused me, and I know for a fact that it's incorrect, and easily you can just pull up my stream and see me looking at the docket, buying documents real time while you guys are here with me. It's difficult for me to take in at pure face value some of the litigation, some of the filings and representations that come forth from Blackburn. And even through this stream today, he's saying one thing in the affidavit and he's citing to the exhibit. But when we pull up the exhibit and I'm reading the exhibit with you in real time, my conclusion about my interpretation about what I see in that exhibit, I do not think matches the characterization in the affidavit. So my thought process, I've got my own tinted glasses that I look at this through because like my personal experience of having something I've done completely misrepresented by Tyrone Blackburn. And all that being said, this has been a hot mess to file. We've got 2 big streams still to do to catch up on the 3 lawsuits, and then also on the in Dixon v. Cartagena et al., the Rock Nation Tyrone Blackburn sanctions battle back and forth with possibly new allegations of hallucinated case citations. So that's going to be a time. Hey Ray. Hey Ray. Good to see you. Good to see you. Derek, I don't even think I'm neutral. I mean, when I think beyond the norm, I have a gripe with Tyrone Blackburn. It was unintentional. I'm just like, at first, I'm covering this case, and it's like, I don't know, this seems kind of sus, but I'm trying to be transparent about what's more recently happened that now I'm just like, ugh, whatever. Um, but I don't really think I'm necessarily neutral. I just like to consider, hey, if this means this could be true. They're saying this. If they have this, that would back that up. Or I'm looking at that and I don't really think that that shows that, you know. I hope that people know that my thought process is my thought process. And if you guys look at the primary material and have a different takeaway, I'm totally open to it. Switzerland neutral. The old Geneva. Oh my goodness. Oh, yeah, outsider and says, oh, I think you're doing the right thing by keeping the docket as your source. Hate all the he said, she said, although even in the docket, that's sometimes the case. Yeah, and I mean, right now, I mean, maybe a few minutes after I end this stream and check the docket again, maybe some of the stuff that we look at will be stricken from the public docket. But unfortunately, for better or for worse, we've already looked at it. I do want to be clear, and I don't say this lightly. But I did read the deposition that's purported to be from someone who's claiming to have experienced like SA while they were underage. The timing of it is causing me to raise an eyebrow. I don't see why in our representation of Terrence Dixon we wouldn't have brought this person forward sooner through discovery. So I don't like to sit here and say, hey, I'm questioning something that's coming from someone claiming something, but I also find it necessary to be skeptical. And this might be the exact type of thing that might not be on the docket if we refresh the case later today or tomorrow. So I've already talked about something that might become off docket, but it is what it is. It is what it is. Let's see. Well, let's wrap that up. You know, I wanted to check out Andrea Burkhart. I've been learning a ton from her, watching her coverage of the Tyler Robinson preliminary hearing. Which I've got to say, if you're interested in following something, even if you don't really care about the underlying case itself, Andrea Burkhart is going to get my #1 recommendation of a place to just go and tune in. You know, there's also been great arguments from the media lawyer because there's been some objections raised to broadcasting certain exhibits to the media. So the media lawyer is stepping up and making a lot of arguments, it seems like every hour or so in the Tyler Robinson preliminary hearings. And it's been great to hear those arguments. So, again, another thing, you may not care about the case itself, but it's been very interesting to see the arguments so far. It's a little slow moving. So, start it late and watch on 1.5 speed 2 times. But I wanted to redirect to Andrea earlier when we did our Courtney Clenny stream earlier this morning. And I'd forgotten that they were having like a half day, just an afternoon day for Tyler Robinson. And they're also Mountain Time, 2 hours behind me. I'm East Coast. But she should be live now. So maybe we can actually do that redirect now. And if you don't already know Andrea Burkhart, does a lot of appellate work, very experienced attorney, great perspectives, great insight. Will tell you, and I think she's inspirational. She'll tell you exactly when. She's like, hey, I have a perspective on this that's based on a personal experience. Here's where I'm anchored, and here's why I view things from this particular position. Like she'll give that framing. I think it's very respectable. Let's see. Cool. So we can do that because I wanted to do that earlier. It could just be an attempt to get in past the deadline. It's like that. I appreciate you guys. I appreciate you guys. Yeah, Derek, I love it over on Andrea's channel. And she's not live often. She like when she dedicates, she picks a case that she wants to cover, she'll be in it from like gavel to gavel for the long haul. So whenever she is covering something I like to check out over there, it teaches me a lot about the law. Her basis for reasoning, her way of thinking through like logical reasoning. You can tell that she studied philosophy. It's just very interesting to hear her reason things from different perspectives. I just really, really like her for a lot of reasons. So that's where we will be redirecting. Again, to me, it doesn't matter what case it is that she's covering. She's always got a great and insightful perspective. And great questions come in from the chat that she takes the time to answer thoroughly. So with that being said, again, our next updates, if it's anything small, like, I mean, you guys heard it here, but if I saw this after the stream, I would have put a pinned comment under this video or done a community post, Twitter post that's like, hey, also there's like this 1-page request to seal. I wouldn't do another live. But in the near future, we will get together again and catch up on these 3 lawsuits because it's like hundreds of pages. We're going to whittle that down to one of them and then pull whatever's like substantively different. We'll pull the highlights from the others too. And then we've got to go over the ongoing sanctions battle in the companion case. So that's what's next on this channel in relation to this case. If you're following any other cases, Courtney Clenny has a status hearing tomorrow. I don't think it's not going to be a motions hearing. They're trying to set that for the end of this month. But there have been some recent motions filed in that case that we did a stream on this morning and last week. So if you want to catch up on that, that's going to be a slugfest, right? That's a self-defense case, domestic partnership, toxic relationship. So it's going to be a battle of, well, she was reacting to him as the abuser. No, he was just reacting to her as the abuser. And then what actually happened on the night of the fatal stabbing, right? That's going to be a slugfest of he said, she said. So if you're interested in those kinds of cases, Courtney Clenny should be going to trial in August of this year. Maybe, finally. Rashawn Jones, another very old cold case, really heavily relying on an eyewitness who's no longer available to testify, who didn't even witness the shooting, just says he walked past a black man on the sidewalk near around the time that he heard the pop noise. That's another interesting case if you want to follow that. There's a lot of issues going on with public access potential gag orders on the attorneys for the retrial. Rashawn Jones was tried earlier this year, and it ended in a mistrial after the jury hung, reportedly, according to media outlets that spoke with the juror. This is a Florida jury, 6-person jury, split 5-1 in favor of acquittal. 5 people of the 6 wanted to acquit. And the state's retrying. That trial is currently set for September 14th of this year, and there's been a lot of docket activity. Those are 2 other cases if you're interested, criminal cases. This one's civil. If you want to, we've spilled into the criminal realm. If you want to follow 2 other cases, I'll probably be doing some updates on those 2 cases before the next stream on this case. But until we meet again, guys, until we meet again, that's how I felt at Outsider in 1. I was not interested in the Clenny case at all. And then the state stepped in it. The state just has this whole side story, and they end up getting in trouble. A judge finds that they violated attorney-client privilege, shouldn't have been looking through communications. Lead prosecutor steps down to save the case, to save the state from being disqualified from prosecuting this case entirely and having to go over to another prosecutor. Just a hot mess for no reason. So I unexpectedly got interested in that case, and now in it to the end. But I totally understand that perspective, and I really feel like, why color outside the lines when the case is like, it seemed like an easy case to win? And then you caused all these delays. And quite frankly, I think the defense in the Courtney Clenny case has used that time to their advantage. So it is what it is. Interested in seeing how it plays out. But that was my perspective, and I got interested for a different reason. With that being said, guys, thank you for coming in and hanging out today. Big thank you. Also, EJF, I saw earlier you dropped the link to, and hey, J Money, I saw EJF drop the link to /star over on X. Great person to follow. Posts a lot of court updates on cases that are kind of under the radar. And again, really appreciative of /star because providing the raw material, the docket material, I think it's the best way. We can all have our opinions about what that stuff says, but I think it's great that we can discuss our opinions on the source material and not have to decipher what's even happening on the docket, right? I hate that there are cases where you have to rely on the basic facts of what's actually happening through the filter of someone else reporting on it or someone else reporting on someone else reporting on it. I just think it's great that people are interested in these things and put the information forward. Whatever opinions we make of it, it's our prerogative. We all have our own prerogative, and it's easier when we have the source material to work with. So yeah, EJF, enough is enough. The extended goodbye. This should take us over to Andrea Burkhart's channel. Hope to see you there or wherever we meet again, and see you guys soon. Bye, guys.